So good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, May 13. So again, please, as you are well aware, um, you should ask for the time. Please ask for the time that you actually need to get out the salient points of your arguments. We have read the briefs. We are familiar with those arguments. Kane v. Haniff. Appellant. How much time are you requesting? 5 and 5. And then Kane v. Kornberg. We don't have a respondent on that one? Okay. So I'll give you 3 minutes on that. People v. Monet Duzant. That matter is submitted. Forston v. Thompson. Did you want any time on rebuttal? 5 and 2 and 5. Matter of H. Children is submitted. Left v. Blodgett. Respondent? 5 and 2 and 5. Zakhanova versus Ogay. Okay, so you don't tell me who you are, just tell me how much time you want. Appellant, how much time do you want? Yes, Your Honor, 6 and 2. Respondent, how much time do you want?
For the respondent, we do have alternative grounds for affirmance or vetoes. We request 7, otherwise 5.
So it's 5 and 2 and 5. People v. Kevin Avila. That matter is submitted. Stein versus Rockefeller University Hospital.
The appellant, 7 and 2, please.
Hey, Your Honor, for the respondents, just to start, I'd like to introduce my co-counsel, Rosa Graves, an admitted pro-hoc PJ, and request that he be able to participate in this appeal.
That's granted.
Thank you, Your Honor. 7 minutes, Your Honor.
6 and 2 and 6. Grove Equities v. Diaz. How much time? 5 2 5. People v. Robert Wilson. That matter, I'm sorry.
For appellant, Your Honor, and I request 6 and 3.
5 2 5. Arancibia versus Silver Lining Inc.
For the appellant, Your Honor, 7 and 3.
Respondent, which respondent? I'm sorry? Okay, how much time are you? Okay, 6 and 2 and 6. Thoreau v. Rezikoff.
Appellant, 7 and 3. Respondent, 7.
6 2 6. EXRP 14 Holdings v. LS-14 Avenue.
Good afternoon. For appellant, 6 and 3.
6 2 6. People v. David Martin.
Appellant requests 7 and 2. People request 6 minutes, Your Honor.
5 2 and 5. Birnbaum v. Chan. That matter is submitted. First case for argument is Kane v. Haniff. Yes, you go first. You may proceed.
This is an election law matter to invalidate the designating petition of the respondent.
Yes.
The election law, as
If you
well
could
as,
just keep your voice up a little bit, or speak closer to the mic. Yeah.
the election law is very clear, as well as case law, and well settled in this division as well as the sister divisions. So any candidate that has knowingly and willingly engaged in fraud does not have the right to be on the ballot and should be removed from the ballot. Here we have the respondent who not only forged 2 signatures, among other things, but she signed as a witness for those forgeries. That alone should have her removed from the ballot. Okay. This matter was not heard in its entirety in the trial court because respondent raised service of process issues. The only argument raised by the appellant for service of process was that the mail portion of nail and mail required overnight delivery. But this has already been settled by the Court of Appeals when Angletti v. Morial, where they said the mail portion is auxiliary or just a friendly reminder, and there's no requirement in the statute or the case law that says overnight delivery. All it says is imminent delivery. There's no language of overnight delivery. The respondents were served by substitute service, mail and mail, and the attorney was emailed a copy of the
Doesn't election law 6-153(3)B require overnight delivery?
well, the order to show cause authorized and specifically permitted the three types of service used, and the order to show cause is jurisdictional. It must be strictly complied with.
But the petition was for lack of specificity, right? Wasn't that the reason? Wasn't that the basis for your petition?
No,
There were objections. Were there not objections to the filing, right?
the
To the petitions.
objection raised by the respondent is that the mail portion of the nail and mail was not by overnight delivery.
But my question was, under the election law, where your petition is objecting to the to certain issues does it not require that it be overnight mail?
No, does not. And as I said, the order to show cause authorized numerous forms of service. The three forms of service used was specifically requested in the order to show cause, which was signed, and the order to show cause is jurisdictional and must be strictly complied with.
Anything else?
The respondent raised no other arguments as to service, and the court ordered a traverse hearing. The traverse hearings was used as a fishing expedition. This is not the purpose of a traverse
Well,
hearing.
the court ordered the traverse hearing, so were you not therefore obligated to go forward with the traverse hearing?
Yes, I did go forward with the traverse hearing, but there was no sworn denial. There was no specific as what was being contested. There was no way for me to come up with an argument or defense when there was no sworn denial. Also, the court ordered a traverse hearing with less than 24 hours notice. I reached out to the witness, the server, was not able to get in touch with him.
You didn't wait, you didn't reach out to him until that morning, right?
No, because I received the order to show cause was emailed the night before. I didn't see the order to show cause until 9:30, and only information I had was work phone numbers. So I could even called, I wouldn't get anyone. So I waited until early in the morning to call him. And even if I did contact him before, the court didn't allow enough time for a public defender to appear. I'm not sure which attorney will be able to clear their whole calendar.
Well, isn't it the whole issue is that there is this has to be done expeditiously. There has to be immediate action because these issues have to be reviewed and they have to be decided in order for the election to go forward.
Yes, the all service was done on the last day of the limitation period. The court did not order the traverse hearing for over a week. So, not sure why that happened.
You have time on rebuttal,
Thank you.
I believe.
May it please the court, my name is Ali Najmi on behalf of Respondent Council Member Shahana Hanif. In this matter, the court correctly dismissed this frivolous petition, an unspecified fraud claim, on two different grounds of service, both of which were sound. The
So
first,
in terms of the election law, does it not require overnight mail, or is that not
so
correct?
Your Honor, actually with respect to the statute that you brought up, I cited it in my brief. That 61543B is related to the service of specifications in the board administrative process. But and the reason I cited it is because in the Angletti versus Morial decision,
Right,
what
we
does
talked
imminent
about-
delivery really mean?
Right,
Right.
so-
and
right.
so as an analogy, everything in election law is overnight. It has to be done right away. And in fact, the facts in Angletti versus Morial, imminent delivery, in that case, the service is done by express mail. And so
Well, here it was United Postal Service first class,
at which
which is,
our
like, what is
submission,
it, 2 to 3 days, something like that?
if you're lucky,
Yeah, well,
you're
I
lucky.
mean, but they state it's, I believe they state it's first class is 2 to 3 days.
which I think we can agree is not imminent.
Yeah, right.
And so, in fact, in election law, it's unlike other matters of the law, it has to be fully commenced within the statutory period, and it has to be done very quickly. So it's nail and mail. It's got to be affixed, and it's got to be sent by imminent delivery. If you allow first-class mail, then you've gutted the decision of Angletti versus Moriel. You've basically taken away the standard of imminent delivery.
What about the argument as to the Travers hearing and the inability to be, for her to be prepared for the hearing? And also, is it correct that the judge did not order that hearing for over a week?
We had, I believe, ample notice to have this hearing. As we had several days' notice. It was not, and in fact, the judge, in the initial return date, petitioner stands up and gives, volunteers some information that she met someone randomly on the street who she didn't know before to serve these papers. That immediately caused suspicion between myself and I think also the court. And at that point, the judge said, you better get this person ready because I am going to issue a Travers hearing. The words Travers hearing came up in the initial return date. She may have gotten notified, and he said to get her ready. And in fact,
Well, she may not know what a Travers hearing is.
I can't speak for what she knew or didn't know, but that's what was said. And what I can tell you, though, is on the return, when we finally then we have a Travers hearing, and she makes us, the referee's report speaks for itself. And, on the final return date, she actually just uploaded a transcript this afternoon. In the final appearance, she states, quote, I could understand that if I was a jury member or a witness in this court and somebody came in and said that the story that there's some random person on the street agreed to serve, I would dismiss that as a cockamamie story myself because it sounds so ridiculous. And I would submit to you that all the facts she put on about this process server from every point that she stepped up in this court justifies a Travers hearing that happened. And what happened at the Travers hearing, she couldn't even produce the alleged process server.
Can I just ask her, petitioner's argument that the allegations of improper service were unsworn and that there wasn't a chance to know exactly what the objection was to service. Can you address that?
Well, I would state that first, the absence of a sworn denial of service is not fatal pursuant to the Johnson v. Deas case. And I would state that in that case, there was documentary evidence that raised issues of fact. And I would say here, in this case, petitioner's own admissions are of the same weight as the documentary evidence in that Johnson case. And so the judge in the lower court, when they hear what she's saying about the process server, rightfully so granted the Travers hearing. And our answer did plead improper service, as well as the issue specifically with whether it was done.
Was that the attorney making those allegations of improper service? Was there anything from respondent
No,
saying that there was improper service?
there is no sworn denial of service from respondent.
So how are you entitled to a Travers hearing then?
Because pursuant to Johnson v. Deas, an absence of sworn denial of service is not fatal in that case where there was documentary evidence that raised issues of fact.
What's the
Here,
documented evidence?
in that case,
No, in this case.
and here I'm trying to argue that her own admissions on the record about how she met this process server, the lack of knowledge of who the process server is, any information that she just met him randomly on the street,
So she's saying it's proper service, and then she makes that statement and she gets her own case, so you get a Travers hearing?
that's what happened because the admission was so incredible that the judge and the court and we felt that Travers hearing was appropriate. I would also say even if the Travers hearing shouldn't have been granted, the service is still improper because the order was defective in that it doesn't match the standard of over imminent delivery with Angletti versus Moriel on the last day to commence service on an election law proceeding.
Ms. Kane, actually, I'll give you 1 minute in rebuttal. This individual that you met on the street, was this individual stated to you or identified to you as a process server, or was it just an individual who you asked to serve the papers?
The respondent engaged in what I call hopscotch citations, where he read my statements in the court, but forgot the second part where I stated, yes, I would assume that was a cockamamie story myself, but this person was worked in a legal field and understood my frustration with election law to get the service done and
So this person was a process server. This is what
he
they
is a
did?
public defender, a federal public defender that assisted me and who understood why I was so frantic trying to get this done. Okay, the respondent is saying imminent delivery. You know, the textbook, Merriam-Webster dictionary definition of imminent is proximity, closely. Okay, and Glady and Morial already states that the nail portion is the service. The mail portion is in lay terms, a friendly reminder. Okay. Also, I filed a motion for sanctions against the respondent because in his brief, he made numerous false statements that can clearly be refuted in the referee's report and the transcripts. I tried to get the transcripts today. I was not able to because of bureaucracy. Okay, this is very clear. He was not entitled to a traverse hearing. The traverse hearing was a fishing expedition. The traverse hearing, he needed to state specifically what the defects was. The information contained no defects or discrepancies. There's no sworn denial. Nothing in the traverse hearing was substantiated. I assume from my, that the respondent has never navigated the world as a woman. So just that he doesn't believe a man is willing to do something for a woman he's
I
just
don't know that
mad,
we could, I don't know that we can go there. But
doesn't
any,
mean.
but your time is up on
doesn't
this
mean
one.
anything.
And so then the next one is Kane v. Kornberg.
This is also a case for invalidating a designated petition for fraud. The respondent also had numerous issues in her petition that pertain to fraud, one being that the petition contained multiple names and a sticker was placed over the address of one of the candidates after they were signed. There were numerous signatures that will appear to be forged because anyone can, doesn't require a handwriting expert to see then, maybe a similar signature, but when the signature is like completely different, I think that a person can clearly conclude that that is not the signature of the person that is on record with the Board of Elections. In this case, they also argued service is improper. However, their reason for arguing service was improper was that the service ordered an order to show cause, which is email, which is jurisdictional and must be strictly complied with, was made upon the Campaign Finance Committee. They argued that the email served, which was obtained from the candidate's official campaign website, info@mayaforcouncil.com, was associated with the Campaign Finance Committee, which would make it improper. However, after close examination and asking the respondents to who is the campaign manager, with no response. Did the respondent hold any positions in the campaign finance, such as treasurer? No response. And after further inspections and contacted the campaign finance board to examine the registration, there's no record whatsoever info@Maya for council was ever or is associated with the campaign finance. An exhibit from the campaign finance was attached to motion sequence number 2. The person listed on the registrations is a different name. The location, there's no evidence of that. So that argument is out the window. So as far as this remains, is the court to decide if this numerous issues of fraud, which were shown in motion sequence 2, warrants the removal of this candidate from the ballot. Also, the ballot, the petitions contain numerous numerous candidates. One being for
Numerous
mayor.
what? They contain numerous?
Candidates for different positions.
Yes.
And as I petitioned myself and gathered all my signatures myself, I often came across the situations where people are saying, I was asked to sign for mayor, and I really don't know who else I signed for. So I believe that the way that petition is structured and the way that people approach their compelling speech by forcing these people to endorse this candidate, or the compelling association by compelling these people to associate with these candidates. And also, if I wanted to sign a petition for, let's say, Ms. Kornberg, a district attorney, I would be compelled to endorse and sign for my opponent.
Thank you. Fortson v. Thompson. Yes, you may proceed.
May it please the court, I think this is a case where the facts are not really in dispute. I don't think there's any question that the plaintiff stepped in front of the truck 4 seconds after the light had changed. At a minimum, I think there should have been a finding of comparative negligence as a matter of law based upon the clear violations of the vehicle and traffic law by the plaintiff. My position is, Your Honors, as you're aware, the Court of Appeals in the Rodriguez case ruled that a plaintiff need not show freedom from comparative negligence in order for there to be a finding against the defendant. All I'm asking for is that the converse also be true, that there need not be a finding that the defendant, and I have the second point on my brief, but the defendant need not show freedom from their own negligence in order to get a finding of comparative.
You sought partial summary judgment on liability on the fact that, with the argument being that plaintiff violated the vehicle and traffic law, right?
Yeah, and actually, I had two arguments, Your Honor. Obviously, I asked for summary judgment totally, but in the alternative, if you were going to find an issue of fact as to what my client did, under the facts and circumstances of this case, the plaintiff should have been at a minimum. Comparatively, negligence is a question of law. The standard 5 questions on a verdict sheet. All I'm asking is that questions 3 and 4 have to be answered yes under the facts of this case.
You want the questions of both plaintiff's negligence and plaintiff's negligence being a substantial factor of her injuries to be determined as a matter of law.
Yes, and I think under the facts of this case, when she steps in front of the truck after the light changed, I don't see how she could be negligent and not being a proximate cause of what happened here. And I cite to the 4th Department case, which I understand the 4th Department case of UTEG is not binding on this court, but that is a situation where the 4th Department adopted the argument that I've suggested here, that the defendant can get summary judgment as against the plaintiff in a situation where the 4th Department then found that there was issues of fact as to what the defendant had done.
So viewing the evidence in the light most favorable to plaintiff, there's no view of that evidence that would indicate that the defendant's negligence, if any, was the sole proximate cause?
I don't think so, Your Honor, not when under the facts of this case, and that's what the second part of the argument that I equate this to being a pedestrian dart-out case. The plaintiff is walking down 8th Avenue. She's walking in the travel lane, and after the light changed, she cuts in front of the truck. It's all on video, and if you watch the video,
We've all watched the video.
there's a woman with the baby carriage walking
Yeah, we saw
across, and my guy waits until that woman is clear before he proceeds, and at that same time, the plaintiff is darting in front of the truck. I don't think that, I think,
An issue of a question of fact as to whether the driver should have seen her dart, as you say, dart in front of the truck.
I'm going to suggest no under the facts of the case. I think it's a,
But when viewing the video, though, you do see that her head, right, coming in front of the truck.
yeah, and as my expert had pointed out,
I
that's
know
not,
your expert stated that that was not the perspective.
but even if you're going to find an issue of fact as to that, I don't see there's any way that the plaintiff can be found no negligence whatsoever under when she cuts in front of the truck after the light changes.
Not to disparage the plaintiff, but I don't know if dart is an action she was capable of achieving.
Yeah, I mean,
her
she has a
age and-
walker. She's she's using the walker in order to cross the street, et cetera.
The reason why I referenced the word dart is I guess I'm used to the term the dart out cases. We know that's how I'm equating it. And, I understand she has no memory of what happened based on the deposition. My reference to dart is just a reference to the way we generally refer to those cases as dart
But
out.
what about your client, though? Because he is eating while driving, and he's rather focused on eating. And also, he's in a truck, right? So is there any additional, should there be any additional thoughts in terms of his really not focusing on what's going on? Should he have looked out the side view mirror?
My position is, number one, he wasn't eating when he started moving the truck, and you can clearly see he's paying attention.
Did he put I don't know.
But he did say, if I read this correctly, that had he not been eating, that he would have been more attentive and maybe looked at the mirrors.
And we can say that is he's obviously very guilty about what he has a guilty conscience as what happened. He's trying to justify it. But even if he notices the plaintiff in the side view mirror, does that give him the foresight that she is going to cut in front of the truck after the light changed? I think one of the points I made is that reasonable foresight doesn't require prophecy. The plaintiff makes a big point that she had been visible for a while in the side view mirror, but nobody expects him to be just watching her in the side view mirror. He's watching the woman crossing in front. And even if he knows she's walking down 8th Avenue, when she should have been on the sidewalk, that doesn't foretell that she's going to suddenly cut in front of the truck after 4 seconds.
Well,
after.
there were other vehicles and there were other trucks on 8th as well, and I think a couple were, one or two might have been double parked, right?
Yeah, she's kind of in the travel lane.
She's in the traffic.
And to foresee that she was going to suddenly cut in front of the truck, I'm not going to use the word dart, but make an action to move in front of the truck, I think I'm going to argue, if my position is unforeseeable as a matter of law.
Thank you.
May it please the court. My name is Michelle Levine, and I'm from the law firm Gerger Conason. We
So,
represent
counsel, where in your papers do you address the issue of the violation of the vehicle and traffic law?
of the defendant's violation, the
Yeah.
truck driver. So in our papers,
No, your client.
Our
Your
client,
client,
okay.
yeah, your client's violation of the vehicle and traffic law.
thanks for the question. So in our papers, we argued that in general, comparative negligence is an issue for a jury to decide. That's how it's typically decided, and that's where we covered that. Now,
Well,
Is there any scenario here where the plaintiff is not negligent?
I think we would have to concede that there would be some comparative negligence by our plaintiff, but it's our position that
And is that concession based on her violating the vehicle and traffic law in the way that she crossed?
I think this is all consideration for a jury. I think we would have to concede some comparative negligence on our part, but our position is that that doesn't mean that the defendant himself was not also
it
negligent.
does not mean that the defendant would be entitled to partial summary judgment on that issue?
Yes. But our position is that that doesn't absolve the defendant from his own duty to observe what should have been seen in front of him.
Well, she wasn't in front of him. That was the whole issue, right? She wasn't in front of him. She was to the side.
So,
And the light had the light had changed. He had a green light.
before he started moving, she was in front of the truck and to the right and visible for about 2 seconds in that video that you referenced. She's there. She can be seen at the right front of the truck and then moving to the right center, and she's visible both out of his windshield and also in the mirror. You can see on the video. Now, backing up before that, our expert opines for a whole 17 seconds before that point, she's gradually moving forward around the side of the truck. And in fact, in one of the videos, you can see her outside the passenger window.
It's not
from where
alleged that she's visible in that rearview mirror for 17 seconds, right?
She's visible for several points throughout that in the mirror.
17 seconds, is that what you're alleging?
Yes, 17 seconds, and in particular, next to the passenger side of where the driver is sitting, she's seen outside that window. So at his deposition, the defendant was
She's
shown.
seen by who outside the video? Who was she seen by?
She's visible. She should have been seen in the mirrors, and the video shows her there as well.
Even if she was seen in the mirror, does that mean that the driver is supposed to anticipate that she's going to turn in front of this truck after the light is green?
So our position is this driver had a duty to see what there was to be seen. Yes,
What there was to be seen, but not to foresee that she's going to walk in front of the vehicle after the light has turned green in the driver's favor.
well, she is visible in the front for 2 seconds before he moves forward, and that's part of what
The
makes
light is
this.
green.
And
Sorry.
also, but their expert says that that was not an angle from which the driver could have seen her. So yes, we saw that on the video, but that was not within the driver's area of visibility.
Understanding that's their expert opinion, she was still
But
visible.
did you
in that
counter
part
that
of-
in any way?
I'm sorry?
Did you counter that opinion?
Yes, yes. Our
And your
expert
expert
submitted
said
an
that he
affidavit.
he would have seen it?
Our expert opines that she would have still been visible in that mirror before he moved
I'm
forward.
not talking about in the mirror, I'm talking about in the front-looking video where she's seen like right at the base of at the bottom edge of the video.
Right.
Is that from a mirror or is that?
She would have been visible in a mirror and through the windshield as well. And you can see in the video.
I'm sorry, does your expert say that she would have been visible through the windshield by the driver?
Our expert opines that through the mirrors she would have been
Through
visible.
the mirror, we're talking about through the windshield.
through the windshield.
Because we don't know, it was unclear as to how the camera was actually posted, how the camera was.
I think that shows there are so many questions of fact as to what should or should not have been seen in the mirrors, in the windshield.
Is a driver obligated to look at the side mirrors when they're proceeding forward after the light changes?
At a red light, this truck driver had a duty to take even minimal efforts to look up and see what was around him. The fact this woman was right there and he testified at his...
He didn't do that because he stopped for someone that was crossing with a carriage, so he was definitely looking. The question is, again, what my colleague asked is there any known duty when you're going straight from after stopping at a red light or a stop sign or whatever traffic device for you to look in your side view mirrors when you're proceeding straight?
The fact that he saw one woman crossing the street did not absolve him from the duty to see all other pedestrians reasonably in the area to be seen. And the fact that our client was approaching from behind, walking right next to his truck for all this time he sat there, he had a duty once he saw her, and he should have seen her at some point in that 17 seconds, particularly when she walked right next to him and was standing there. He had a duty to see her and avoid colliding with her under both the VTL and the common law.
You said reasonably to be seen, and I'm still having trouble with why it was reasonable for him to have seen her.
The defendant driver testified at his deposition that had he checked the mirrors, he would have seen her next to the truck, approaching the truck, walking alongside the truck and around the front of the truck.
He would have then had the foresight to know that she was going to cut in front of a truck after the light changed in his favor.
Well, there's a duty once he sees a pedestrian on the road to see where she is.
So once he saw the pedestrian on the road, he was to do what?
He was to ensure that he would not collide with
And he
her.
actually kind of did that, because she crossed in front of him.
Well,
I'm not really understanding how he could have prevented her from crossing in front of the truck.
this case is different than a so-called dart-out case.
It is.
He is not driving at 50 miles an hour and he doesn't have time to stop. We're talking about him coming
But he
from
had
a
already
stop
stopped,
position.
and he had stopped. He was at that red light for some time. It wasn't a situation where you stop at a stop sign, you pause, you look, you keep going. He had been at that light. It had been red for a substantial period of time. And as my colleague stated, there was a woman who came, you walked across with the carriage. The light is green. There was a portion of time where he's still at that green light before he takes off. It's not like the light turns green and he immediately, takes off.
Yes, and
Justice Higgett?
I just want to go back to something earlier. You mentioned, and I commend you for making a concession, which I think is a reasonable one, that your client was negligent for one or two violations of the VTL. I'm curious, does that concession carry with it as well a finding as a matter of law that that negligence was a proximate cause of her injuries? Not the sole proximate cause, but a proximate cause of her injuries?
we would have to concede that. But again, because that does not free the defendant of his own duty to see her. And again, while he is stopped at that light, even though he's waiting for the first woman to pass, she's still visible right there to be seen. And he should have seen her. He admits he would have seen her had he checked his mirrors, had he not been distracted. At the end of his deposition, he says, had I not been distracted by all of this, by the eating, by the music, I would have looked up and seen her. And if once you look up and see someone right in front of you, right next to you, you can't just blow forward. Even having the right of way, and we cited some case law on this. There's one case, Colpan versus Allied Central, I was going to mention. Even a driver who has the right of way is not absolved from his own duty to observe the roadway and to keep a proper lookout. And in this case, where he testifies, if he had checked the mirror, he would have seen her right there, and she had been there for some time next to him. Then he would have had a duty to avoid hitting her, even if he had the right of way.
Thank you.
Thank you.
Very briefly, I think a lot of the points have been made. I just want to pick up on the question Your Honor asked about what's reasonable to do. And I think the issue is there a duty? He's clearly looking ahead. He didn't jump the light. The question is, does he have a duty to check the side view mirror when he's going forward for somebody who's doing what this plaintiff did, and whether he could reasonably have anticipated? And I don't think the timing is exactly the same. And I think if you look at our expert report, because he's pushing a walker, she's down low. If you look at her expert report, they got somebody who's like 6'6", and it's very obvious. Whereas I don't think she is as visible from the front as somebody who's even my height.
Does plaintiff's expert report refute your expert in that the driver would not have seen the plaintiff from where he was sitting in the cabin vis-a-vis what is seen on the video?
I think their expert report really focuses on what would have been seen in the side view mirror.
On the side view mirror. That I agree, but I don't recall them specifically refuting that, with your expert saying that the driver would not have seen her in this position.
My best recollection at this point in time is I don't remember that either.
That's fair. Okay.
So there are issues of fact then as to exactly what was seen, what was not seen, when he saw it or when he should have seen it?
I would say that under these circumstances, because she's from the side and because this is a different case than the one where you're approaching the intersection of the example Your Honor used at a stop sign and somebody cutting across, because she's from the side, my suggestion is that there's not, that she cut in front unreasonably under these circumstances, and the driver's actions, I don't think the law requires perfection, it requires reasonableness, and I don't think his actions were unreasonable as a matter of law under these circumstances.
Thank you. Thank you both. Left v. Blodgett. Left v. Blodgett.
May it please the court, I'm Stephen Chackwin, and this is kind of a straightforward case. There are a couple of segments to it. I'm going to start with what I think is the easiest one for all of us, and that is the scope of discovery, which we call the excessive scope of discovery, included in the court's order. Now, what you have there that struck me, just on medical records to start with, is one of them is every record from every provider, excuse me, that Mr. Left saw from the year 2008 to the present. So if he saw a dentist, they get an authorization for it. If he saw a podiatrist, they get an authorization for it. If he had dermatological problems, they get an authorization for it. And it seems to us that when the only body part or condition that are at issue have to do with his spine, his shoulder, and possibly his knee, that's way off in left field. However, it's also not atypical here, because with the 3 hospitals that they're asking for records of, they want them unrestricted by time, unrestricted in every possible way. So we've already given them everything we know about for his spine. We've given them everything we know about for his shoulder, which is basically nothing. And we've also thrown in his right knee. And these go back as far as they go. And from our point of view, that's what they're entitled to. And it's what every personal injury defendant in every case like this would be entitled to. And I've given you in my opening brief something like 18 cases from this court and a couple from the Court of Appeals that all say the same thing. There's nothing revolutionary in our position. And so I don't think that there's anything much to talk about on that. Of course, I'm not the judge, so you may have a different point of view. The next thing to talk about is what I call the Eisenman issue. And that has to do with poor Ms. Eisenman, who went to her doctor in Delmar and came down the stairs the wrong way. And the defense lawyer there said, well, she's there, she's going downstairs, maybe she didn't see something. So why don't we get her optical records? Why don't we have her looked at by an ophthalmologist? And the third department said, no, that's not an issue. That has not been put in issue by the plaintiff. She's not alleging eye damage. She's not alleging visual damage. She hasn't put those in. They still remain privileged. And I have a nice little section, I think in my reply brief, where I say how wonderful the physician-client-patient privilege is and how long we've had it here and that we were the pioneers on it. There's no reason to change that now. This court, as I've reminded you in my opening brief, has followed the Eisenman case. The Court of Appeals has followed the Eisenman case. If it's good enough for you and it's good enough for the Court of Appeals, it's good enough for me. As to they've backed off on the psych exam, which is to their credit. And what we have left is the issue of whether we have to create evidence for some meaningless purpose. Mr. Left is not making any claim of lost wages. He doesn't get wages. He's a partner.
Did you formally withdraw the lost wages claim?
I don't know how, well, we didn't send in a piece of paper that said, I withdraw it, but he testified in deposition that he is not making that claim.
But he didn't withdraw the statement in the bill of particulars to the contrary.
No, the bill of particulars didn't say anything definite on it. It said
To be
To be
determined.
determined.
to be determined.
Right.
So,
And he stated to be determined, and also that following the accident, he had stated he missed a couple of days of work.
right,
And worked on an altered work schedule. But the question is, did he specifically state, or has he specifically withdrawn any claim for lost wages?
that's what we think his testimony stands for. We're obviously happy to put a piece of paper in front of the court on that, but there's nobody here who says, in this case, who says in any way, shape, or form that Mr. Left is claiming lost wages or lost earnings. So there was a placeholder in the bill of particulars, which we could have done better, but there's unequivocal testimony by a person who is a personal injury lawyer, a partner in the firm that's prosecuting his case, and he says nothing on wages, nothing on earnings. So I think that's as far as it can go. And in any event, well, that's what I think, but in any event, what there is also just the whole structure of this kind of practice. We're a personal injury law firm. We don't bill by the hour. We don't track our hours. We don't.
So we don't want you to have to bill any more time. So you can talk more in rebuttal. Thank you.
I appreciate the help, Your Honor. Thank you.
May it please the court. I'm Stephen Zaklakevich from Milber Macris, Placidus, and Sidon for defendant respondents. Plaintiff has suffered 3 lumbar spine injuries. 1997, we think, 2008, we think, and 2023, the case we're litigating right now. On each occasion, plaintiff has treated with doctors and radiologists for injuries to his lumbar spine. We don't know when the treatment began. We don't know if the treatment overlapped. We don't know if the doctors exchanged medical information with radiologists. That's why we asked for authorizations unlimited as to date. Plaintiff's statement that we're looking for podiatry records or dentist records, it's a red herring. We're simply looking for discovery related to a lumbar spine injury that he's alleging today was exacerbated by the accident in 2023. And all the case law states that as an exacerbation, we're entitled to see what those doctors said in 1997 and in 2008.
So you recognize that if you're entitled to authorizations, they would be limited to the injuries
Absolutely.
being pressed in this case?
Absolutely. We don't know the time. We don't know the dates. That's why we put in the language unlimited as to date. If plaintiff can come and tell us, okay, look, he started treating with Dr. Jones on March 1st. Okay, can we get an authorization from March 1st? We'd be happy to accept that, but we have not gotten that.
Would a written notice from counsel formally withdrawing the lost wages claim that was reflected as to be determined in the bill of particulars, would that, in your eyes, moot out the request for plaintiff's calendar?
Well, Your Honor, that's a very good point. Very good point. The insurance law of New York, the serious injury portions of the insurance law, has a section about whether the activities of daily living during the first 90 out of 180 days were in any way curtailed by the injuries that the plaintiff is alleging. Those records, the calendar from his practice, will show us, did he go to court? Was he able to conduct a deposition, virtual or otherwise? Was he able to go to a conference? Did he
I
travel?
thought he specifically testified to that during his deposition.
He testified that he did certain things
Right.
in relation to his personal injury practice, but he didn't state with any specificity whether those items were reduced to an office calendar. As such, that type of, if there's nothing there, there's nothing there. But to say we're not going to give you anything is another
So
issue entirely.
was the answer yes or no, that if there was a formal withdrawal of a claim for lost wages, would that foreclose your request for the work schedule, his calendar?
I don't, the work schedule goes to two issues, Your Honor. It goes to lost wages. If he's saying I don't have any lost wages, that's.
What else does it go to?
It goes to what his daily activities were like in those first 180 days.
And
Could
that
I
goes
work?
to
Could I
what?
drive?
And that goes to what?
It goes to whether or not he sustained a serious injury. And that's under the motor vehicle, it's a motor vehicle case. If I can prove that he didn't sustain a personal injury by virtue of what it says in his work records, I'm entitled to that, respectfully.
What about the ophthalmologist?
Well, Your Honor, regarding the eyes, we didn't just walk up and say, let us, we want to investigate your eye records. We want to have an IME based upon the fact that you're nearsighted. What we got from Mount Sinai Hospital, pursuant to an authorization provided by plaintiff, was a diagnosis of retinopathy sometime in plaintiff's past. Plaintiff gave it to us. He didn't seek to protect that information. He provided it by an authorization. We found out that this type of retinopathy specifically goes to your ability to drive safely, your ability to operate heavy machinery safely.
And that would be a very potent point towards the discoverability of further information vis-a-vis the plaintiff's vision. Do you have any expert evidence that supported your motion that
At this stage of discovery, Your Honor, we have no expert. All we have is the diagnosis in plaintiff's medical records that was provided to us by way of an authorization. We did some background research within the hospital who provided the records, and they said, look, this type of retinopathy is a serious condition. So this clearly goes, now we're out of damages. Now we're into liability. Did this retinopathy contribute to plaintiff's comparative negligence in the happening of this accident? I argue, Your Honors, that plaintiff waived the privilege that he's now asserting when he gave us those records. And secondly, he waived the privilege when he stated in his bill of particulars, I am completely without fault. This accident happened entirely due to the fault.
Well, the records were turned over not for anything as to the eyes. The records were turned over for something else. So I don't know how you can make the argument that he waived it. He didn't know that those records were also going to contain information concerning his eyesight.
I don't necessarily agree with that, Your Honor, for this reason, respectfully. He had the opportunity to review those records. He could have redacted that. He could have moved to protect that information from coming into my hands. He chose not to. To me, by giving me the authorization, permitting me under HIPAA.
Does that mean he's putting his eyesight at issue?
It's clearly putting his eyesight at issue, Your Honor, because he's saying I was without fault. I drove properly without negligence. I did what I was supposed to do. It's all on Mr. Blodgett. Now, to me, when you're saying I have this type of retinopathy, it at least deserves to be investigated, discovered. I'm not speaking to admissibility. I'm stating that we should be entitled to get the records to see how compromised his vision was as a result of this condition.
What case law do you have to support that your claim that he could have contributed to the accident waives his privilege against producing medical information?
I'm sorry, Your Honor?
That constitutes a waiver of his privacy on medical information?
Specifically, we don't have a specific case, Your Honor, but as it relates to these facts, it's almost as a case of first impression. He specifically.
You argue it as a case of first impression on that issue?
No. What I'm saying is the fact that the condition is in controversy,
But put there by you.
Not necessarily, because as I said, plaintiff is asserting that he is without fault. Now, without fault means that he was capable of driving that vehicle safely, properly, using, just like the PJI says, I can see what there is to be seen. He's asserting that he was without negligence, and therefore he's putting it into controversy, and the records waive it, and his assertion that he's without fault also waives it.
Does it matter at all that the allegation is that your client's vehicle swerved into his vehicle?
Both drivers, my client has yet to be deposed, Your Honor. We're alleging that this accident was caused by plaintiff's negligence. It's a sideswipe accident on the Hutchinson Parkway.
Right.
Right. So the fact, I think both parties are arguing that the other caused the accident. And
Your argument is that by claiming that he was without negligence, that puts his eyesight in issue. Is eyesight not always an issue?
eyesight is always an issue, Your Honor, yes, because every jury hears that I was supposed.
So that in every, my point would be that in every accident, should you get an authorization for someone's records?
No, I believe that if, as in this case and as in some of the cases plaintiff has cited, if there is a reasonable reason, I'm trying to remember the language. If there is a good faith basis for finding out more information about whether or not your eyesight was compromised, in this case, the retinopathy, then it comes into issue. Then it becomes.
And have you done that? I'm sorry.
Absolutely.
And that's not something on which you have any authority, right?
I'm sorry?
And that's not an argument for which, that's not a principle for which you have any authority, right?
Any authority.
Any precedent? You said a few minutes ago it was a case of first impression on that issue. So I just want to make sure we're still there.
So we'll take a look at the briefs again as to waiver. Thank you.
I would ask the court in response to Her Honor, McGlone versus Port Authority, 90 AD 3rd 479.
And it's in your briefs, right?
Thank you.
Thank you. Counsel, did you want to address that last point in terms of?
Yeah, I think that's a good starting place. Two things that I need to frame this. One of them is that they deposed Mr. Leff for a whole day. They could have asked him anything they wanted to, and they didn't. Ask him anything about his eyesight beyond, are you nearsighted? And he said that. So now they found this thing in his records, and if we had screened his records before we gave them to him, you'd hear them all the way down here from their offices, wherever they are.
If you had redacted that portion of.
Right, if I went around redacting records instead of giving them an authorization for it. So I can't do that, and they know that. More importantly, what they also know, and we've said this in our brief a couple of times, is this is a diagnosis that was made 10 years ago, one treatment, that's it. So this is, I'd hoped I'd be the first.
That they know of.
Right, well, that he knows of. And I'd hoped I'd be the first person in this court today to talk about fishing expedition, but your election case beat me to it. So I will say that this is completely out of left field. And also, it's a complete mangling of the applicable law. We have the Coomfey-Smith case from way back in, good heavens, 1969. We have the Dillenbach case from, it's much more recent, that one's all the way up to 1989. And what they say collectively is he can't put my client's condition in issue. He doesn't have permission to do that. I can do it with my pleadings. I can do it by alleging something like a claim against him based on my guy's condition, but he can't do that, and we haven't done that here. And so he's on some sort of quest of obfuscation here. As for the threshold issue, which he sort of alluded to in this whole calendar thing, first of all, Mr. Leff testified, although you didn't get told that his calendar is not going to say who covered what day and whether there's any difference between before and after, because that's not this kind of practice. We're not We're not a regimented kind of practice. We respond to the needs.
Does it go to serious injury under the insurance law?
Right, but here's where, first of all, they could have asked him anything they wanted to for the 9180 in the deposition. They didn't. And also, he's been through a spinal fusion, a lumbar fusion. And one of the things that happens when you have a lumbar fusion is that there is a part of your back that will never move normally again. So I think that his talk about needing this for a threshold motion is nonsensical.
Thank you. Thank you both.
Thank you.
No, you can't. Thank you. Zakonov versus Algai. I know I said it incorrectly, but I'll try it again. Zakonova versus Algai? Oh, see, I was close. Say it again. How do you pronounce it again?
Zakienov, Your Honor.
Yeah, enough. Thank you.
May it please the court. Good afternoon, Your Honors. My name is Mark Lindeman for the appellants. The U.S. Supreme Court in Kirkpatrick clearly stated that the act of state doctrine only applies when the outcome of the case turns on the validity of a sovereign act, and that is not the case here. Furthermore, there are no judicial proceedings, no adjudications entitled to comedy in this particular action. There was no adjudication.
Counsel, assuming
Yes.
we agreed with you about that, why wouldn't we dismiss it based on forum nonconvenience?
Yes, Your Honor. There is no available forum. There is no available alternative forum in which this matter could be heard.
Your client has brought many proceedings, apparently, in the courts of Kazakhstan, so he obviously views it as an available forum.
There's a difference between run-of-the-mill commercial proceedings and proceedings that go against individuals who are part of the ruling elite of Kazakhstan. In the complaint, the U.S. State Department's report indicates there is corruption and that the judicial process is influenced by the ruling elites, including the oligarch defendant Edward Ogai. Should this case be heard in Kazakhstan, we could expect not only the remedies that the plaintiffs are seeking not reached by the Kazakhstani
I don't
court.
remember your expert specifically raising that issue and arguing that for your client, they were not, for this kind of case, they were not an available forum. Is that in your expert's affidavit?
The expert's affidavit indicates that Kazakhstan follows the local doctrine action, the local action doctrine, in which Kazakhstan can only adjudicate cases of real property wherein the real property.
But that's not what I'm asking. You seem now to be arguing that Kazakhstan is not an appropriate forum because your client is, or was adverse to the former president, and therefore politically, for a case like this, it's not a realistic forum for him. Is that, I don't recall that as in your expert's affidavit.
The complaint expressly indicates that
I'm asking you about the
Certainly.
expert's affidavit. Is there any, am I forgetting something that where you allege that in your expert's affidavit?
the expert's affidavit alleges that certain remedies are not available.
I understand that, but you're now saying that the reason it's not available to him is because of the political nature of his relationship to the defendant in this case and his political history with the government of Kazakhstan.
We're saying that's
Is
one.
that argued in your, and I don't remember that being stated in your expert's affidavit.
Right. We're saying that's
Was
one
it?
of multiple bases for why the Kazakhstan courts are not available as an
Okay.
So
alternative.
the answer is no.
The answer is no.
The answer is no. And I'm looking at the affidavit because I'm reading it pretty quickly, but I don't see that. No, it doesn't say that.
But apart from the corruption that is alleged in the complaint regarding the court system,
Is that something that we would look to in terms of this alleged corruption?
in terms of whether there's a chance for a fair hearing of our client's claims, then the corruptibility of the court and the fairness of the proceedings that are available in Kazakhstan would be something that would be looked to in the course of a form of nonconvenience.
But in order for us to make a finding on that, we'd want something like an expert's affidavit, wouldn't we? We wouldn't just want it based on an allegation.
Well, there are allegations which must be taken as true at this particular stage of the proceedings. However, again, the corruption that's associated with the ruling elite's control of the Kazakhstani court is just one of the
Okay,
reasons.
putting that issue aside.
Okay.
Is there any other reason we shouldn't dismiss it based on forum nonconvenience?
New York has a superior interest in this case. There are three particular reasons. One, the substantial nexus that the actions and the parties in this particular case have to New York. With regard
Wait, they are citizens of Kazakhstan. 3 of the 4 individual plaintiffs live in Kazakhstan. The 4th one lives partially in Kazakhstan and partially in New York. I'm having trouble understanding why the ties to New York are greater than the ties to Kazakhstan.
Right, the tie to New York is the allegation that the monies were laundered through the properties that were purchased here in New York. The Riverside condo, I think there was a condo downtown, but anyhow, that the monies were laundered through those condos.
Yes, Your Honor. And looking at
So how does that constitute a substantial nexus given the fact of where the other individuals reside?
with regard to cases such as City of Almaty versus Abyazov, as well as Unaria Shopping Center, the fact that the funds that were misappropriated entered New York gives New York the substantial nexus. Also, with regard to this court's decision in Lebanon v. Sotheby's,
So although they were allegedly laundered through New York, the documents would be in what language?
the documents concerning the transactions in New York regarding the New York properties would be in English.
No, the documents concerning the mine and the actual setup of the business. Those documents are not in English, right?
Those documents would not, but it would not be a
Right,
major
they would have to
imposition
be
on the court.
translated, and those individuals who were the keepers of those documents, perhaps the ones who actually executed those documents, those individuals would have to, I don't believe speak English, they would have to testify through a translator?
A number of them may have to speak through translators, Your Honor, but again, there are two sets of fraudulent transactions that are going on here. You have the knowing receipt and transfer of misappropriated funds by the New York LLCs.
That assumes then the underlying transactions were fraudulent or otherwise tortious, and the underlying actions all allegedly occurred in Kazakhstan.
Right, and not in New York. But you have time on me, Bottom.
Thank you, Your Honor.
Good afternoon, Your Honors. It's Donald Hawthorne for the respondents here. I'm from the firm of Curtis Millay Prevost. I'd like to just pick up on one comment that was being made before about the availability of Kazakhstani courts. A couple of points. One is that, as the court noted, the plaintiff, one of the plaintiffs, has made use of those courts recently, and it was indeed for a high-profile litigation, as the papers show, over a mine in Mongolia, actually. And he was also tangling with other senior members of Kazakh society in those cases. I would also point out that in terms of the availability of Kazakhstani courts, it was part of the plaintiff's story that he was unable purportedly to discover certain issues about this case until a change of government. And he said it was only after January 5th, 2002, the key witnesses were finally able to speak truthfully and disclose to the plaintiffs relevant information, which supports that whatever the issues may have been in the past about a Kazakhstani forum, those are in the past.
But you will agree that the remedies are somewhat limited, right, in terms of what.
Only limited insofar as that there are limitations on the ability of a Kazakh court to impose a constructive trust over New York property.
Right.
On the other hand, it's undisputed that there's no need to do that. The defendants are wealthy individuals. It's uncontested they could satisfy a judgment. They've consented to jurisdiction in the courts of Kazakhstan for the purposes of this litigation. There's simply no need for anyone ever to come after those New York properties, and no reason to burden a New York court and potentially a New York jury with adjudicating a case about Kazakhstani events, where even if plaintiffs are right, they could be
Would there
satisfied.
be a limitation also in terms of obtaining the documents, not only from New York, but also from California?
Certainly, the ability to acquire documents under 1285 in service of a foreign litigation from the United States is a path that's frequently taken. We've taken that on behalf of clients many times. That doesn't seem to be any particular impediment to proceeding with the case there. And we think the court was correct and well within its discretion of dismissing also on the basis of comedy, under typical comedy analysis. There's certainly an available forum in Kazakhstan, and given considerations to the fact that there was a prior bankruptcy proceeding there. Your Honor, I'm sorry, do you have a question?
If we were to disagree with you as to the active state doctrine, what basis for dismissal would you press that we consider as an alternative at this time?
Well, we raised 4 of them, but I think the first point could just be what the court said below. The court said the word comedy in the first sentence and comedy in the last sentence of its
Right,
decision.
but those are, I mean, I read those as being in tandem with the active state. Turning to the others of your motion, bases to dismiss, where would you focus?
This is clearly a forum nonconvenience matter. It's hard to imagine a clearer one where the arguments under forum nonconvenience, all the traditional tests, public interest, private interest, all sway us in favor of moving to the forum of Kazakhstan. We've also made 2 additional arguments in the alternative. One, there is no standing here. The only injuries that are alleged are injuries to the SK Corporation, but this is not brought as a derivative claim. There's no standing here. And in addition, there's no claim stated. These are events that occurred over 20 years ago. Any claim for conversion or unjust enrichment ended then. Under New York law, there are very limited circumstances where a fresh act of conversion could occur in New York, and those require, for very good reason, a specific object, like an artwork, or an identifiable fund. Neither of those exists here. There's a long, imaginary, hypothetical trail that supposedly leads the funds into the New York apartments, but don't provide a basis for any claim. And so we believe that for that reason as well, really for all 3 of those grounds, the case should be dismissed, as well as on comedy principles, since you have...
I'm not asking you to cede those. I just wanted to know what alternatives you would push the hardest.
I would ask for those 3 alternatives, all of them. And I do think that it's important that there was a foreign bankruptcy proceeding going on. The nature of this case shows exactly why it's important. If plaintiffs are right and there's a claim here, the claim belongs to SK. And that's a claim that doesn't belong to a few people who happen to be shareholders. It's a claim that belongs first to creditors. And there was a bankruptcy for SK, so we know that it had creditors. They come first before any shareholders. And of course, there are other shareholders. It would be completely improper for one set of shareholders to zoom in and scoop up this asset if it really were an asset. And that's why comedy counsels, as the court below said, comedy counsels deferring to a bankruptcy proceeding in Kazakhstan.
Thank you.
Thank you.
Your Honor, with regard to counsel's pointing to the bankruptcy proceedings, that's hardly an example of a proceeding that had integrity. Looking at the allegations of the complaint, the bankruptcy proceedings were riddled with fraud and controlled by defendant Edward Ogai. With regard to the specific
argument, what about his argument that the creditors are the ones that have standing?
These causes of action are alleged as the result of private actions by private actors. The ownership interests of the plaintiffs were stripped by the defendants prior to any bankruptcy proceeding. The shareholder registry was doctored. Their interest was removed. Their interest, the plaintiff's interest, was removed from SK. In addition, the profits and dividends that are outlined in paragraphs 50 and 92 and 93 of the complaint, profits and dividends are specifically identifiable funds for the purposes of conversion, and those were stripped of the plaintiffs. At the same time, their ownership interest was also taken away by the defendants. Again, these are private actions by private actors involving no acts of state, involving no adjudications prior to any bankruptcy proceedings. That's when these causes began to accrue with regard to defendant Edward Ogai. And again, with regard to the U.S. entities, the New York State limited liability companies, with their knowing receipt and transfer of the funds that Mr. Ogai misappropriated, they point to the reasons why this case should be heard in New York at this particular time. And again, just pointing your court's attention to a city of the City of Almaty versus Ablyazov and the Unaria Shopping Center. In those particular cases, the courts did look at the initial misappropriation abroad and then looked at the funneling of the proceeds of that initial misappropriation into New York State real estate. And in both cases, it was found to be proper to be adjudicated in New York, and in fact, in the Southern District, they granted the plaintiffs relief over what the defendants had done in misappropriating and laundering the funds into New York State real estate.
Thank you. Thank you both. Stein v. Rockefeller University Hospital.
May it please the court, Eminette Hasapidis appearing for the plaintiffs in this case. Respectfully, the court erred in holding that the Gender Motivated Violence Act, or the GMVL, was neither a revival statute nor retroactively applied to revive my client's claims, which are dating back to the 60s and the 70s. The court was sympathetic to the defendants and was concerned that there was non-perpetrator liability against the defendant for acts that had occurred years ago. The plain language of the statute, however, does not support the claim.
Would you agree that that statute the 2022 amendment to that statute really creates a new cause of action?
No, Your Honor, it does not. It is.
So the accomplice essentially liability is not a new cause of action?
The liability, are you referring to the entity liability? In the 2022 amendment, the city council held that essentially that entities like defendant that facilitated
right, facilitated or encouraged, et cetera.
That was a clarification of the statute, and this was all based on the Violence Against Women's Act. The GMVL.
But in terms of under New York law, it was a new addition, correct?
It was a new addition. It was a new
cause of action under New York law, right?
Yes, if you ignore, yes. But for statutory interpretation purposes, the purpose of the GMVL was to restore a right of action that New Yorkers had until...
This is 20 years after more than 22 years after the VAWA was declared unconstitutional.
It was, which was why there was also a revival window here created by the 2022 amendment. The city council knew full well what it was doing and the fact that it was imposing liability. The city council pointed out that this was a clarification because the VAWA previously imposed entity liability. And it was supposed to, the GMVL was supposed to track the VAWA, and the 2022 amendment was intended to correct that omission.
But it was still a new cause of action under New York law at that time, right? It hadn't existed previously in New York.
Yes, it had not existed before, yes. But again, it's a revival.
So isn't there then, if it's a new cause of action, then giving it retroactive effectiveness has due process considerations, doesn't it?
First of all, they did not argue due process. Secondly, it does not, again, because you cannot tether and ignore and I'm not saying you are, Your Honor, the Violence Against Women's Act from the GMVL. The whole genesis of the GMVL.
I understand that.
Well,
I don't
we can't
understand
ignore
how that changes the retroactivity analysis when there had not been a similar cause of action under New York law ever, including for that previous 22 years.
I understand that, but again, Your Honor, we have the revival window. You don't even need to look at retroactivity when you look at the revival window.
Okay, so what was revived by virtue of the 2022 amendment?
Any civil claim or a cause of action brought under the chapter. Your Honors, I would not be here if the statute said a cause of action brought under this chapter and accruing after the year 2000 is hereby revived. I wouldn't be here. No cause of action. But that's not what the city council did, because the city council's intentions were to correct what is deemed a societal scourge. This is sexual abuse and sexual violence. And just as in the Child Victims Act and the Adult Survivors Act, there were revival windows. And in many cases, the defendants made the same complaints in those cases that they do here. Hold it, we were never liable back then.
You're arguing that the 2022 amendments revived the let's call it the abettors liability when it didn't exist.
Yes, but if this court looks at this case of Spiegel, in Spiegel, this court held that Civil Rights Law 75-B, the amendment to that statute, was retroactive. In that case, the amendment imposed for the first time liability against private employers. And it was an exponential increase in liability. And this court was mindful of that, but nevertheless held that it was retroactive. The
Okay,
city
so,
council,
but now we're talking about two separate things, right? There's
Right.
revival on the one
Right.
hand, and then there's retroactivity on the other.
but the spirit is the same here, that this is a wrong that we're trying to correct. You're right, Your Honor. We are going back to another
Well, the
thing.
city council, certainly, that's its purview to correct whatever evils it chooses to. It's up to us to figure out what did they intend to do here, and did they intend to either apply to the 2022 amendment to apply retroactively? If not, there's revival, and does the revival include the cause of action you're pressing?
Yes, it does. So if you look at the section 10-1104 of the Administrative Code, it defines what cause of action is. It says a person who is a victim of a crime of violence motivated by gender shall have a cause of action. So that's the definition of cause of action here. In the next section, 10-1105, which is the revival window, the city council said that a civil action, okay, not saying a cause of action, a civil action, which is much broader. A civil action includes a complaint with multiple causes of action. It's very broad. A civil action under this chapter shall be commenced within 7 years after the alleged crime. Okay? So we have our 7-year statute of limitations. Then we move to the revival portion. Notwithstanding any provision of law that imposes a period of limitation to the contrary. Hold on. They just told us it was 7 years. What else could we be referring to here, notwithstanding any provision of law that imposes a period of limitation to the contrary?
The revival provision specifically says it only applies to claims where the applicable statute of limitation has expired. But as to this cause of action, the applicable statute of limitations hadn't expired because that cause of action didn't even exist.
But I'd refer the court then to Doe versus Wilhelmina Models. In that case, it was a CVA case, and the defendant there said, hold on, the predicate for the CVA charge here is a crime that did not exist at the time of the offense. It was the crime was sexual performance, and at the time of the events alleged in the pleading, it applied to children under 16. Whereas the allegations in the complaint there applied to those who were 16 and 17. And this court, reading the purpose underlying the legislative history, said it applies. Based on the legislative history and the framework that's here, it must apply. So while it seems in Congress we cannot ignore the overarching reason why the city council acted at all. This is victims of sexual violence. You've seen, Your Honors, many cases over the last few years concerning the Child Victims Act and the Adult Survivors Act. And what trumps every consideration of fairness that the defendants in these cases complain about is the fact that victims of this type of abuse do not come to terms with that abuse until many years later, which is why we have revival windows, which is why
But the revival windows are specific and certain.
and they are here. This is without any limitation.
You have time on rebuttal.
Thank you.
May it please the court, Doug Ulver-Dreemeyer on behalf of Rockefeller University. The 2022 GMVL revival window did one thing. It revived time-barred claims brought under the GMVL for a 2-year period. But as Judge Gonzalez in the Eastern District recently held in the Roldan case that we submitted as supplemental authority, at the time of the GMVL's amendment, the plaintiff's claim hadn't expired because of the statute of limitations. It had never existed. And if a claim has never existed, it cannot be revived. So the GMVL's revival window does no work for the plaintiffs. It only revives those causes of action brought under this chapter. This chapter is Chapter 11 of Title 10 of the New York City Administrative Code. That is the GMVL. there is no revival of claims that don't arise under the GMVL. And plaintiffs' reading that hives off any civil claim and suggests that that is not limited by the language brought under this chapter would suggest that any claim, even if unrelated to the subject matter at all, a contract claim, any claim could be revived, could be filed and would be timely even if it had long expired under the applicable statute of limitations. That reading is not required. In fact, it is contrary to the use of that phrase throughout relevant statutes. The CPLR uses the phrase any civil claim or cause of action more than a dozen times. It uses that phrase because it encompasses both those actions that have already been filed, which are civil claims, and those that are incoming.
Appellate cases that have adopted the position that plaintiff is arguing?
No, Your Honor. In fact, there are 12 decisions that have held either that the GMVL itself was not retroactive, notwithstanding that it had also a helpful, beneficial purpose, or that the GMVL's amendment in 2022 is not retroactive. There is no claim, no court has held that the GMVL or the 2022 amendment creates liability for a non-actor like my client for conduct that predated the GMVL's enactment in 2000. This conduct predated even the enactment of VAWA. So the suggestion that somehow New York was trying to close the gap, fill the gap left by VAWA's overruling by the Supreme Court doesn't help these plaintiffs because VAWA was only enacted in 1994. So they asked this court to do what no court has done. And there are...
These plaintiffs could have come within the CVA, right?
Yes, Your Honor, they could have come within the CVA. And I wanted to point out that the CVA uses the same phrase, any or every civil claim or cause of action. And then it has the limiting language about conduct that would constitute a crime under one of the enumerated provisions. Under plaintiff's theory, the analysis in Wilhelmina that counsel pointed to was irrelevant. It was unnecessary because even if the conduct would not have constituted a crime under one of those provisions, you could just say, well, I don't like the cause of action language because it's limited. I'll just proceed under the any civil claim provision, which is not so limited. But that doesn't make sense. In fact, if that were true, then the child limitation of the CVA would not limit the any civil action, nor would the adult limitation of the ASA limit the any civil claim, rather. So we know that the limiting language applies to the entire clause, and that is consistent with the purpose of the statutes, which is to create a limited revival window. These plaintiffs could have brought a claim under the CVA. They did not. The revival window of the 2022 amendment to the GMVL does not help them because they never had a claim under the GMVL, which postdated their alleged conduct by many years. If the court has no further questions.
Thank you.
Thank you, Your Honor.
Counsel referenced supplemental authority that he provided. I did not receive notice of it or anything. Plus, federal court authority is not binding. Any additional authority that was submitted, I'd ask that the court disregard on that basis. My client's claims against the entities were expired. Once the 2022 amendment went into effect, the claims, they had causes of action under the entity provision, and therefore you then turn to 10-1104, which revives the claims.
Counsel, you were copied on that via NICEF.
I was.
The supplemental authority.
Was that recent, Your Honor? I'm sorry. You know what? I will check that. I did not recall receiving.
Yeah.
It was a couple of days ago. Okay.
I did not recall receiving that. I am sorry, Your Honor.
You see, counsel, what I still don't, I still can't wrap my head around the fact that the statute specifically says that revives any claims that were barred because the applicable period of limitation has expired.
Right.
Those claims didn't exist.
They did once the 2022 amendment went into effect. The same time this amendment went into effect, my clients had expired claims against the entities, and this revived them.
Expired because
They went into existence upon the enactment of the 2022 amendment simultaneously. It's the same.
So you're saying even though they predate VAWA,
Yes.
even though,
Yes, even because the revival window is not limited in that fashion. There's no case law that says a revival window only applies as far back as the enactment date of a statute. That's speaking to retroactivity, not revival. Revival is not limited. Retroactivity, I'll give you, could be limited to the date of the VAWA in this case. Revival is everything. There's
So
no
you're reviving something, you're reviving a claim that now exists based upon this amendment.
That's correct, because the city council was that concerned.
Does not make sense. to me.
Councilwoman Rivera published on her website, I referenced this in my reply brief,
Yeah, I saw that, yeah.
an admonishment that just because the Adult Survivors Act window had closed, that doesn't mean you don't have recourse under the GMVL. And I'd make one final point. No appellate court has addressed this issue. It is one of first impression. Judge Tisch in the JL versus Rockefeller University case did state, and this is quoted here, that because the revival window had opened and the claims were untimely under the CVA, it appears that plaintiffs now have the opportunity to pursue a separate CVA
case
action.
didn't go up, right?
It did not, but it was against Rockefeller University, Your Honor. So Judge Tisch construed this as allowing them to pursue entity liability against Rockefeller University because they no longer had viable CVA claims. I thank the court for its time, unless you have further questions. Thank you.
Grove Equities v. Diaz.
Good afternoon. May it please the court. Eugene Myers on behalf of appellants of the firm My Sicilian Fine PLC. As provided in our briefs, motion in court should have held a hearing on damages because there was a genuine issue of material fact existing as to whether the liquidated damages amount constituted a penalty. If the court held such a hearing, it would have found evidence that the liquidated damages amount included usurious interest, time-barred amounts, as well as holdover rent that is unenforceable against the guarantors. The liquidated damages amount of $1.4 million is grossly disproportionate to the amount that the guarantors would actually owe, which was $178,000.
What did the settlement state? The settlement agreement, what did that state?
The settlement agreement stated that if the tenant did not pay the installments on the settlement amount, then the tenant and the guarantors would be liable for an amount that was characterized as a current arrears.
And so is that not what we're dealing with here? Is that amount not current arrears?
Our position is that the amount that's characterized as current arrears is unenforceable because it constitutes usurious interest, time barred by the statute of limitations, as well as unenforceable as grossly disproportionate to the actual amount due.
didn't the settlement agreement reduce the amount of arrears by about 30% and provided for a payout plan, like staggered payments, so that they could keep up with that?
So as with respect to the tenant, I would agree with that. With respect to the guarantor's liability was far less than the tenant's liability.
Was the guarantor, were they parties to the agreement?
So the guarantors did sign the stipulation. However, the guarantors were not parties to that civil court action. The civil court didn't have jurisdiction over the guarantors. That was subject to a Supreme Court action. And the guarantors, as I mentioned, would only have been liable for a fraction of the amount. I would say even the tenants would not be liable for the entire amount because it included usurious interest, which is void against public policy, as well as in the initial summary judgment motion in this case, the landlord conceded that there's about $600,000 of usurious interest.
I think my colleague was going to ask whether you ever argued that, whether that was ever.
I'm sorry?
Is that what you're going to ask?
That was.
Please, I missed it.
Was that ever argued before?
Which part?
What you talk about the usurious rate and all the other arguments that you just made about why you need a hearing as to damages here.
So those arguments were raised on the summary judgment decision that's being appealed here, and the judge did not address it in the opinion at all.
So wait, you did in fact raise the argument as to that it was a usurious rate?
Yes, in
The prior proceedings, in the prior
yeah.
proceedings.
Right.
That you raised those arguments.
So the arguments were raised in the proceeding on the summary judgment motion seeking to enforce the stipulated amounts. We opposed that motion seeking a hearing on damages because it included usurious interest and
Did you make those arguments before you stipulated to what you stipulated to?
those, as far as I know, those arguments were not raised prior to the
But
stipulation.
what gives you the right to make them now?
But there were made, I'm sorry, there were arguments made with respect to statute of limitations, which led to the landlord seeking to reduce the amount because they were barred by the statute of limitations. Those arguments were
The way
raised.
Stipulation works, right? So then now you have the stipulation. What gives you the right to now undo that?
Because the stipulation is barred against public policy and statute as provided in the case of trustees of Columbia University,
Your
which
clients had lawyers at the time they signed, had a lawyer at the time they signed the stipulation, right?
that is true. There was an attorney that signed it. The client was not present at the time. But his attorney signed it.
I thought your client signed the stipulation.
No, it was a true attorney stipulation that was signed by the.
They didn't move to vacate it on the grounds that the attorney didn't have a.
No, they did not move to vacate on those grounds. I'm just stating the facts.
So there's no argument that they were not aware of the contents of the stipulation, nor that they did not agree to the contents of the stipulation.
Not that argument. There was a motion made in the civil court to vacate it on the basis of duress. We're not raising an appeal on those basis. We're seeking that, but that was a tenant's argument. So in this case, it's the guarantors who are in before you and before the Supreme Court, not the tenant.
Guarantors did not argue duress.
Right. The guarantors did not make any argument. They were not parties to that action. The guarantors only are before the Supreme Court, and that's the court that heard this argument, and that's the jurisdiction. The civil court now have jurisdiction over the guarantors. I would also point out that the waiver of objections to liquidated damages amount or to the sell amount is also unenforceable, as it waives statutory protections that are such as usury and the statute of limitations, and under the case law that I cited in my brief.
Thank you.
Afternoon, Your Honors. May it please the court. My name is Eric Pitter. I represent the respondent. This is the guarantor's now third attempt to escape the consequences of the stipulation of settlement they signed in the civil court proceeding. They did actually sign the stipulation of settlement in the eviction case. It was on the day of trial. Then they tried to move to vacate it on grounds of duress. That was denied by the judge. Then they opposed the motion in Supreme Court, where they didn't interpose an affidavit, only an affirmation and a memo of law, but they never set forth grounds to invalidate a contract. That is, fraud, collusion, mistake, or accident. They now rely primarily on public policy arguments, but the public policy that outweighs those arguments is the one where stipulations of settlement are routinely enforced, absent those grounds to vacate those agreements. And public policy arguments are not inviolable shield to the waivers that they signed when they entered into the stipulation. They waived all their defenses, and those defenses were not interposed in any answer. So when the Supreme Court enforced those waivers, Your Honors, it had every right to rely on the stipulation of settlement since those defenses were never an issue. And so the courts are entitled to rely on stipulations of settlement and enforce it with rigor as long as those stipulations are product of mutual accord. And the civil court, in enforcing that stipulation and refusing to vacate it, upheld it as inherently fair, neither unjust nor harsh. And Judge Bluth had every right to adhere to it. Now the guarantors come to court before Your Honors and say it was only a fraction of what was due, but that's assuming that they're not liable for the holdover rent, which the Supreme Court already found in the first motion order that was not appealed and is a final and binding order now. So That's how they get from the 1.6 figure to 178,000. They assume that they're not liable for holdover charges, but that argument fails because the guarantee explicitly says use and occupancy charges, and the lease explicitly says use and occupancy charges are 3 times the rent. So there's no disproportionality here. There's no liquidated damages provision here because it's not an estimate of future damages, and that's what Justice Bluth found in her order. She upheld the stipulation, and there's no grounds to vacate that stipulation. The cases cited for liquidated damages provisions are the cases where there is a disproportionate result. Trustees, Van Duzer, those are all cases where the damages are difficult to calculate in the future. That's not what happened here. This stipulation already provided for an amount that was already due. The parties agreed that's how much was due. And if you comply with this year-long payment plan, then we'll waive 30% of that.
So they defaulted on the payment plan, right?
They defaulted. They made the first payment of use and occupancy, then a $50,000 payment was due. They didn't make it, and they tried to vacate the stip on the grounds of duress. So the consequences of that stip are guarantors, you signed the stip, you agreed that we can enter judgment in Supreme Court if you defaulted, and that's exactly what happened.
Thank you.
The arguments that were raised by respondent as well as in the motion court below regarding the sanctity of a settlement agreement, as well as the fact that the liquidated damages amount needs to be an estimate of damages, were rejected by the Court of Appeals in the Trustees of Columbia University case. In that case, the dissent specifically made those type of arguments, including that there's a public policy to protect settlement agreements, and then the liquidated damages amount to constitute liquidated damages amount must be an estimate. The majority in that case just said that that does not apply, and that settlement agreements, just like any other contract, needs to be evaluated on its face as to whether or not it violates statutes or important public policies such as unenforceable penalties. And another case even more recently than the trustees cases from last year, which is the Leggett v. Lou Realty case, which is a 2024 Court of Appeals case, in which the Court of Appeals also found that a so-ordered stipulation between a landlord and tenant agreeing to waive statutory
That
protections
involved a
was void.
rent-stabilized tenant, right?
That's correct.
Who have specific statutory protections with regard to agreements that doesn't apply to commercial tenants, correct?
Right, and we're not arguing
So
that it's against.
that's really completely irrelevant to your case.
Well, in
Do you
our
have any
case,
better authority than Liggett?
so first I would just we're applying Liggett on the basis that
Do you
statutory
have any
protections.
better authority than
Sure.
Liggett?
That's the Trustees of Columbia University case. And in that case is dealing with a agreement where there's a dispute between a landlord and a tenant with respect to how much is due on the rent. And then there was an agreement that if they paid in certain installments, if they didn't pay on certain installments, they would be required to pay a larger sum. And then the court found that large sum was disproportionate to the actual amount and found it to be unenforceable. And in that case, the dissent made similar arguments that were raised today and disregarded them in the majority. So that's the case that I would say to your honors. Thank you so much.
People v. Robert Wilson.
Always know a case by name. Some of my favorites. You do that.
Good afternoon, Your Honors. May it please the Court. My name is Sarah Chaudhry, and I'm counsel for Appellant Robert Wilson. The prosecution failed to present clear and convincing evidence that Mr. Wilson had a history of substance abuse. Specifically, what the prosecution failed...
We agree, and we subtract those points, still the same level.
Okay, so Your Honor, two things with that. One is if you agree and you subtract those points, I think we can move on to my downward departure argument. But say you decide that there's no downward departure that's warranted here, which I believe that there is, and we can go through that. It still matters what level Mr. Wilson is adjudicated in terms of how many points is he assessed, for two reasons. One, he has a substantial liberty interest in making sure that there's the proper
I don't
assessment.
think I said anything different, right? I just think I said that whether it's 95 or 80 points, it's still a level 2.
Okay, so let's take it from there. If it's still a level 2, why don't we move on to the downward departure argument? Now here, there were many factors auguring in favor of downward departure. First, Mr. Wilson was already on the cusp of a level 1 and level 2 designation. When you're on the cusp, you have to make less of a showing of a mitigating circumstance. Factor 2, which is sexual contact with the victim, seeks to determine how intrusive was the violation here. So that's why you have 5 points if there's touching over the clothing, 10 points if it's under the clothing, and 25 if there's actual sexual intercourse, right? Now, the guidelines identify a mitigating circumstance for factor 2. They don't do that anywhere else in the guidelines. And they say, to the extent that the relationship here was consensual, and the only issue is because of...
Okay, so I'm not understanding. He's 30, she's 15. If I got the case right, am I correct?
Your
He's
Honor-
30, am I correct?
Your Honor, you're completely correct.
Okay, so he's 30, she's 15. He is prostituting, he's sending her out to be a prostitute, and he sells her to his friend for a little less than $400.
Well, let me address each of those. So first and foremost, I'm not here to condone Mr. Wilson's behavior. We're not sitting here and saying, hey, this is a paragon of how you should behave in this specific circumstance.
What are you saying?
What I am saying is that for the most part, Mr. Wilson had a relationship with the complainant that was of housing and employing her. In fact,
Employing her as a prostitute and
No.
selling her, that's a relationship?
Absolutely not. She was actually working at parties where he was distributing marijuana.
She's 15 years of age. I still don't understand where you're going with this. Why should there be a downward departure?
Okay, so can I just take each allegation? I want to just take each allegation, right?
Please.
So we have this idea or this allegation that there was a sale of the complainant. Now, I think we can all agree that that is disturbing and that is egregious. Now, what is it predicated on?
And
illegal.
You're leaving out illegal.
Absolutely, but I would say it's more than anything, we could say it's morally reprehensible if it's correct, right? Now let's look at whether it's correct. The only evidence that there's this alleged purported sale is that the sex trafficker who actually received 10 years on this matter, and my client, the prosecution advocated for him to receive a lesser sentence, the sex trafficker said to the complainant when she was saying, I want to leave this horrible situation, he said, hold on, you can't leave. You know why? Because Mr. Wilson, who you had been living with for 2 years, and you mostly were just, you were a teenager who was living with his family for these 2 years, he allegedly sold you to me for $300. I mean, it's an incredible statement, and the only support for it is a sex trafficker's self-serving assertion. Now, with respect to the age differential, I'm not here to say that that's amazing, but what we are concerned with is, should he be a level 2 or should he be a level 1?
Well, it's not about whether it's amazing. In the cases that you cite, is there any case that the age is double? Usually, the argument that you're making where there's an overassessment that you look at just the age, right? Those are cases where the ages are much closer. They're much closer in age. Here, he is not only is he double her age, but we're forgetting a very important fact here, which is she's a runaway. She is a runaway who's with him, and he's purely taking advantage of her. I don't see how this mitigates at all.
Okay, Your Honor, so with respect to he's clearly taking advantage of her, if that were the case, I would have expected the prosecution to make that argument at the hearing, that they would have said, look, even if she didn't say that there was any coercion or force or violence, we should take a look at the situation and determine there is.
You're comparing the situation with your client with regards to the co-defendant. The co-defendant actually prostituted her, right? That's different. That's different. So that the government, the people treated them differently, that's what you would expect. They had different allegations, different conduct, they were treated differently. But now you're trying to get some kind of windfall by saying the guy that prostituted her got 10 years, so my guy should get something less.
Can I just respond just to your one question? Yeah, your one, and I have more on rebuttal, but I know my time here is up. But to your question,
that's her decision.
Sorry, to your question of do I have other case law where there's this kind of a differential, I would direct your honors to People v. Secor, which I think most, is most applicable here. There was a 26-year-old and a 14-year-old. There was limited sexual
I still don't
contact.
understand where you're going with this. So, okay. Why, again, should there be a downward departure? There should be a downward departure because of what? Why?
Okay, so, well, a couple of reasons, right? One is that as much as I agree with you that this is, it's behavior that makes us all uncomfortable.
Why should there be a downward departure?
Mr. Wilson has a very limited criminal nonviolent history. For 2 years, he was basically with his girlfriend and child. The complainant was living with him. There was very limited
So he had his
instances.
girlfriend, his child, and this young woman there as well.
That's correct, Your Honor.
Excellent. Okay, you have time on rebuttal. Thank you. That made it even better for a downward departure. Yes.
Good afternoon, Your Honors. Andrew Loziz, appearing for the people. Your Honors, there is no basis for a downward departure in this case from a level 2 to level 1.
I think part of the problem is here that you didn't make it easy, right? Because you did give, for whatever reason, you took some mercy on him, right?
Yes, Your Honor.
And so that's fueling her argument. Why was the mercy given? In light of the facts here.
Your Honor, I think given I cannot speak to what my colleague did at the Sorrel Court, no, but what I can say now is this, that there is no reason why this court should depart from a level 2 to a level 1, considering that this defendant trafficked the victim, was engaging in sexual relations with this girl who's 15 years old. He was 30 at the time. Also engaging in sexual relationships with her, with his girlfriend who was living with him at the time, and then just employing her as a bottle girl at marijuana parties, and then sold her into prostitution.
His counsel apparently wants us to consider the fact that he had a girlfriend apart from this woman as an evidence of stability, even though he was living with her at the same time that he was trafficking this this young girl.
That's right, which apparently didn't seem to stop him from engaging in this behavior. And
were any of these mitigating factors already taken into consideration?
Yes, Your Honor. They were already accounted for by the RAI, the risk assessment instrument, and were present before Justice Bruce at the time of the SORA hearing. Your Honors, there is, again, as I stated, there is no basis for a downward departure, and there are no mitigating factors warranting a further downward departure. And unless Your Honors have any further questions, I respectfully submit the rest of my argument on the brief. Thank you.
I just want to make sure I understand. Are you actually asking us to consider that he has a girlfriend as a mitigating factor, even though he was living with the girlfriend at the same time that he was prostituting this child?
Okay, so one thing is...
Is that your argument?
I have to explain it before I
I'd
can
like
say...
an answer.
I can't say yes or no because I think there's a fundamental misunderstanding of one specific thing, which is we present one mitigating circumstance, which is the lack of consent was predicated on age. Now, when my opponent says all of these mitigating circumstances were taken in...
I'm sorry, we've got a problem there. I don't understand why that's mitigating. As a matter of law, the age is critical. I don't understand why the age issue is mitigating.
It's an established mitigating circumstance. It's listed in the guidelines themselves. If you look at...
So even if it is an established mitigating circumstance, that's if that's the only circumstance, right? But when you couple it with she's a runaway, when you couple it with now you have her in threesomes, that you sold her and she's working off her living for sex, it's no longer just about being 15.
Okay, so I don't want to spend too much time on talking about why I think that claim of sale is incredible. If you look at it, well, let's move to something else.
We don't want that red herring.
So, there's also Mr. Wilson, if you're looking at the totality of the circumstances, he had a stellar institutional record. The prosecution itself seemed to be
There were no 15-year-olds, I assume, in the facility.
Well, Your Honor,
never mind.
Your Honor, not to make light of it, but look,
No, not to make light of it. He had no disciplinary infractions whatsoever while incarcerated. He had a stellar term of incarceration. He has a young child. I don't know whether he's still together with the girlfriend. What else?
Well, let me just point something out. At the SORA hearing, the prosecution itself said, we're seeking these additional points because we want to make his case for a downward departure less compelling. Now, on appeal, if this was such a slam dunk case, I wonder why it is that my opponent didn't actually just point to these factors and instead tried to look at things outside of the record. I would submit to you that that in and of itself is indication that there is a compelling reason for a downward departure if we look at the actual totality of the circumstances.
So what would a
which also
downward,
includes,
assuming there was a downward departure, what would that, how would that benefit your client?
well, my client would still be a level 1, which means the community would be notified, right? But it would accurately assess his risk to others. Now, there was a level 2 recently that this court had taken a look at, People v. Cabrera. That person was a level 2 offender, and you guys rightfully so declined to reduce him to a level 1 where there are allegations of grooming, rape, no remorse, no rehabilitation. Mr. Wilson is just 80 points. And he has demonstrated that
Was there remorse? Did he apologize? Was there any remorse on his part?
the prosecution it's incumbent on the prosecution to demonstrate if there wasn't. There's an actual factor that would assess
I know,
points.
but at the SOAR hearing, was there anything from the defendant stating that he was remorseful or anything of that nature?
He wasn't scored any points for lack of remorse, which means that the court, as well as the board, determined that he had appropriate remorse. The very last thing I'd like to mention, because I see my time is up, is that typically this is not a SOAR registrable offense. When you're looking at the totality of the circumstances, I think it's important to look at the actual facts, not just the allegations and not just the sort of spurious nature of some of these allegations. Thank you. I
Thank you.
appreciate your time.
Thank you. Arancibia versus Silver Lining, Inc. Whenever you're ready.
May it please the court. Leslie Corwin on behalf of the appellant Silver Lining, Inc. This case is about fundamental fairness and business morality. One party is adhering to the terms and conditions agreed to in a complex equity transaction 10 years ago. The other party is not. The 3-year non-competition covenant of plaintiff's employment agreement is enforceable as a matter of law, as it was a key component of that larger equity transaction that had a lifespan of at least 3 years. The 3 agreements before this court, plaintiff's employment agreement, the stock purchase agreement, and the shareholders agreement, must be read and understood in conjunction with with each other.
Why is this not overbroad? I'm trying to figure out exactly what type of position he could undertake during that period of time.
You mean now that he's been terminated without cause?
Well, that's another.
He's still.
Well, that's another issue, which was not even addressed, is whether there was or was not cause. But okay. So what type of, based upon this agreement, based upon the covenant not to compete, what is it that he could, what could he do?
He can go out and work, and he can start his own company, which he has every right to do. What he
In
can't.
the construction, if he were to do that in the construction industry, it seems to me the way your the so-called agreement is written is that he couldn't do anything in the construction industry in the New York area or the Atlantic area, I think there was also LA, for 3 years. Anything that was in any way competitive.
That's not the case. He can work today. He can go out and work. What he can't do, and what he agreed to do, was to adhere to the terms and conditions of this non-compete. He can't make use of confidential information. He can't go after our clients.
But it also says he can't directly or indirectly render services
to those clients. And in all of these.
No, or be connected with any competitive business in the New York metropolitan area.
That's correct.
But if he goes out and starts doing construction on his own, then he would be a competitive business in the New York metropolitan area and then run afoul of the clause.
Yes, he can, but he can't go after our clients. He can't use our confidential information.
That's not what it says.
Yes, it does, Your Honor.
It says, from a competitive business.
Correct, and that's all defined, what a competitive business is. And those are the businesses which he...
A competitive business, any business or enterprise which provides construction and or renovation services and other business, product, or service related to any of the foregoing which has been performed or provided by the operations of Silver Lining.
Correct. And that is enforceable as a matter of law. It comes under the reasonable standards of BDO Seidman versus Hirschberg, which has been the standard in New York State for over a quarter
You're not
of a
interpreting that.
century.
Excuse me, are you interpreting that to say that he can go out and start his own business and compete with Silver Lining?
He can. He can go out and start his own business tomorrow.
Why wouldn't that be why wouldn't that be a violation of the non-competition covenant?
He just can't go after our clients.
That's not what the
That's what the agreement says. If you look at all three of the
I'm
agreements.
reading it.
And as a
I've got it
matter
in
of
front of
fact,
me.
Counsel,
the reason that it
counsel,
would-
counsel, just calm down a little
Go ahead.
bit. Okay. So we're reading it, and I've read it numerous times. It does not appear to be as limited as you're making it seem. It appears that he could not engage in any activities in the construction business.
No, that's not, that if you read all of the three agreements in their context, he can't go, there are probably 27 clients, and we say that in our papers, that he can't go after. He can be in the business. He can start his own company. He just can't do it in those geographical areas where we have pointed out, New York metropolitan area, the Hamptons, LA, and in Miami.
So you agree he can't start a business in any of those areas?
He could, as long as he doesn't compete with our clients and go after our clients.
Okay, so what would constitute competing with your clients?
Soliciting those clients. And the reason that he can't do it would be ludicrous.
It's only soliciting those clients. So he could start a business, he could start a construction business in New York, so long as he doesn't solicit your clients?
That's correct. And that's what it says. And that is exactly the criteria where he is a senior executive, highly compensated.
Right.
And the last piece of this thing, which would make it ludicrous for him to compete with our clients, is that to this day, he remains a director and a shareholder under the stockholders agreement until he is bought out. And it would be in violation of the covenant not to compete and a breach of fiduciary duty under Business Corporation Law 717 and dictum in this department, Foley versus D'Agostino, for him as a shareholder and a director of a company to directly compete with that company for its clients.
Counsel, looking at that, I'm sorry. Looking at that clause, it seems to me that you're collapsing the definition of customer and competitive business. I agree with you as to what customer means, but competitive business does not seem to be limited to anybody who has worked with Silver Lining.
Not at all, Your Honor. It's what I've said to you and what the papers show to you.
Papers say.
That's what it is.
And also, we're talking about somewhat of a limited industry, are we not? Because I thought we were talking about luxury developments. Are we not talking about? So it's not like he could go out and engage in the construction of a store, right? Of a regular store.
Correct, Justice Weber.
So we're talking about luxury, which is what his forte is, right?
Which is exactly what is spelled out in all three of these agreements. You're dealing with very high-end, very high-profile residential industries, people who have.
Right, and
that's why it's confidential. If I gave you the names right now, the court would know who they were.
Well, that's why it's but that's his forte. That's what he does. He only knows high-end luxury.
Not necessarily, but he's getting millions of dollars in compensation not to compete with them. That's the agreement that he and the same attorney who represents him today agreed to 10 years ago.
Okay, you do have time on rebuttal. Thank you.
Thank you.
Good afternoon. May it please the court. Adam Oppenheim from Harris St. Laurent Wexler on behalf of respondent Joel Arancibia.
So are we totally incorrect in our interpretation of this covenant?
No.
So
not at all.
So you're not totally incorrect. So your client can go out and you.
This is the first time I've heard from counsel that this agreement allows my client to go out and start his own construction company. I suspect the settlement negotiations would have gone very different from the beginning if they had said that. What the agreement actually says is, as broad as you observed, Your Honor, it's not just that my client can't work in the major industries in which people do this kind of construction renovation, but it's that he can't work with a customer defined as anybody who not only did business with Silver Lining, but whom Silver Lining thought about doing business with. This is a full stop on my client's professional abilities here. That's why it's overbroad. That's why, and you're absolutely right to read this agreement. This shuts him down completely. And of course, as you know from my papers, I think that's a sideshow here. I think the most important thing this court can do is put Colchins to the test. Colchins says that when you terminate an employee without cause, you fundamentally destroy the bargain that the Court of Appeals was talking about in Morris and before that in Post. This case doesn't fit into the forfeiture for competition box that my adversary would like to put it in. My client was terminated without cause. And in the First Department, you cannot tell that person where they can and can't work. The defendant doesn't assail that decision, nor does the defendant assail the underlying logic that it's not fair to fire someone and then tell them where they can and can't work.
Are you saying that if someone is fired without cause, then there's a per se rule that they can't be restricted by a restrictive covenant like that?
Your Honor, actually, I'm not saying that, but this court said that in Colchin. And I'll tell you the decision that it affirmed. This is exactly the argument that was made in the trial court. This is what the trial court said below. Evolution Markets, that's the other side in the case, relies on decisions from other courts which it contends stand for the proposition that restrictive covenants are not, per se, unenforceable in New York against an employee who has been terminated without cause. However, this court is not bound by such authority. It is bound to apply the law as promulgated by the Appellate Division, First Department. Those are the words of the trial court that this court affirmed in the Colchin's decision not that long ago. So yes, I think if you terminate someone without cause in the First Department of this state, you cannot enforce a restrictive covenant to prohibit them from
Counsel, is that, I'm not sure that that's what those cases actually say, right? In terms of when you terminate someone and then there's a non-compete, those cases where that per se rule, so-called per se rule was announced, really dealt with an area where there was a post-employment benefit that the employer was contractually bound to give its former employee. That's not this.
Well, I think there's actually a distinction between those two observations. You're not wrong. But what the courts say in those decisions is two things. First, in the context of prohibition, that is whether or not I as an employer can tell an employee that I have terminated without cause, where they can and can't work, the courts have said, no, you cannot. And that is as clear in Colchin's as it is in the cases that preceded. What is different is the exception to this rule. The exception to this rule that everyone loves to drive a truck through, right? The employee choice doctrine, where courts have said here in New York that it's okay if what you're actually doing is conditioning the receipt of post-employment compensation on forbearance from competition. The problem in this case, of course, is we have no post-employment compensation. There's nothing. The millions of dollars that my adversary is alluding to, that's money he's entitled to receive if an option to purchase is exercised by Silver Lining. That's not what employee choice says, and this is in all the decisions that this court and the Court of Appeals have written about, sorry, I'm talking faster when I see the light, that this court has written about the employee choice doctrine. It means this. It means the day you decide you're leaving your job and you have money coming to you, that you get to stand there and make a choice. Do I want the money, or do I want the right to compete? Mr. Arancibia didn't get that choice. He didn't get on either half of the equation. He didn't decide to leave the job. He got fired. And not only that, there was no compensation he could reach for. He hadn't been promised anything. He had an option, his company, had an option to repurchase his shares. Nobody expects them to do that unless it's smart money, and they haven't done it yet. And he was entitled to a 6-month severance only if he agreed to sign a release that he never signed. That's this case. He didn't get to make an employee choice, right? He was stuck because he got fired and told he couldn't compete. And this court has been very clear about that. You can't do that. That destroys the bargain that underlies the employee choice doctrine, which is a great one. It's just not this case. I have a lot more, Your Honors. If you'd like me to continue, or I can answer any of your questions. Otherwise, I'll rest on my papers. I can read the room. Thank you very much.
I don't know.
Section 803. Let me read to you and let me tell you, this is the whole key to the whole thing and all the questions that you've asked me right now. If you look under competitive business, it shall mean any business or enterprise which provides construction or renovation services and any other businesses, product, or services related to the foregoing which has been performed or provided by operations of the company. That's the key thing. And if you go on, the term customer shall mean any entity with which the company, and then with the company, and with the company. That was always the understanding. He can't go after their customers. He can't go after the construction business of the company. Why? Because he's being paid millions of dollars, in which he had a right to do if he was terminated without cause. And there are cases in this court going back to Morris versus Schroeder, which is a Court of Appeals case. And the most recent case on this is a case called Kelly Hilton versus Silverline, in which this U.S. Court of Appeal, the Southern District, Judge Cote, applying New York law in a case which is almost this case to the T, because there the woman got stock options and was paid her salary as well, and that was held as enforceable.
There's an or there. You kind of glossed over the or. Any business or enterprise which provides construction and or renovation services and or any business related to your company, Silver Lining. There's an or there. There's an or. It's any construction.
I understand, but with respect to the customers, it's only the customers of the company.
It doesn't. It says that he is precluded from any construction or renovation business and or any business related to Silver Lining.
Provided of the company. That's what he can't do, but he can go out and work. He can have his own business.
If he did that, he would be engaged in a business which provides construction and renovation services.
No,
which he is specifically forbidden from doing by paragraph 8.03.
Not with respect to these type of high-profile, high-end residential area. That's what he agreed to. That's what he's being paid with respect to.
And I thought the monies that he was being paid were based upon his stock options and monies that he had.
No, he's getting paid 175% of the value of what his stock is. The additional 75%.
I thought I just said that.
Is the consideration.
I just said that. I said I thought he was being paid based upon his stock options, and then you said no.
Oh, I thought you meant that it was just the value of his stock. I'm sorry.
Okay.
He's being paid, if his value of the stock was $100, he's getting paid $175 because he's not competing, and that's what he agreed not to do.
But so, would he not have been entitled to those stock options and payment of the same?
Yes, but he would only be entitled. He'd be entitled to the stock. But if he competes, he only gets 75% of the value. If he doesn't compete, he gets 175% of the value. That's what the agreement said. That's what he agreed to. And and every single thing within that non-compete clause is within the common law reasonable standard established in this state by BDO Seidman.
So the fact that he's being paid 75% over what he would have normally been paid, that detracts from the overbroadness of the covenant not to compete?
It shows that he's getting compensation for what he's agreed not to compete. As a matter of fact, Your Honor, had he just gotten, and I'll tell you, had he just only gotten to not compete his salary going forward and his stock back, under this court's decision in the Bruderman Brothers versus Goldberg case, which I think Your Honor was the chief judge on that panel.
I'm not the chief judge of anything.
Well, you were the presiding.
I'm the presiding judge.
On that panel, this court held that a non-compete with respect to Goldberg, the defendant in that action, was enforceable as a matter of law. And there he was only getting whatever his equivalent of his salary was for the 5 years in which he couldn't compete. I mean, as I said, this agreement was signed 10 years ago. This guy agreed to all of this in an equity transaction. Twice he ratified that. 4 times the non-compete was renewable as a matter of law, never questioned it once until he was terminated without cause, which the Silver Lining had an absolute right to do under the agreement. And then he brings this action in state Supreme Court. ignoring completely the stock purchase agreement, the shareholders agreement, saying this is a simple employment agreement where you can't enforce it because he was terminated without cause. This court shouldn't allow that to happen. Thank you.
Thank you. Thank you both. Thoreau v. Renicow. Yes.
Good afternoon, members of the panel. Peter M. Levine, counsel for the Resnicow appellants. The most important aspect of today's oral argument will be what you will not hear, what will not be said. You will not hear one word about causation. You will not hear an explanation of how Norman Resnicow, all by himself, independent of all other factors and influences, delayed by 3 years and 8 months the design, the approval, and the construction of Justin Thoreau's outdoor deck. You will not hear this because there is no evidence of this. Justin Thoreau cannot show a delay of even 3 hours and 8 minutes. You will also not hear any admissible evidence supporting Thoreau's claim that his apartment was totally unrentable and had a 0 rental value for 6 years, due solely to Norman Resnicow.
Well, sir, maybe, I don't know that silence helps you because you moved for summary judgment.
Right.
Right? And unlike maybe many of our sister states in the federal courts where the party who doesn't have the burden at trial can move for summary judgment and point to the absence of evidence, we insist on an affirmative showing of entitlement to judgment.
And we showed that precisely. Remember, the damages, as Justice Lebovitz said, are the core of this case. And what did Thoreau say to be his core? 3 years, 8 months. And we showed that that theory, that core, can never be proven. And we showed that with undisputed facts.
Isn't there a testimony from one of the board members that it was probably at least a year delay because of actions?
Let's look at that. Oh, thank you. Let's look at that. Thoreau's plans were approved December 16th, 2017. So let's go back 1 year to November 2016, 1 year earlier. That's when, according to Tim Walsh, based on his very hazy recollection, it felt like a year. He didn't define the year, he didn't define or identify a specific event. He said it seemed like a year. So let's go back. What's the situation in November 2016? The board is prepared to approve Justin Thoreau's plans at the annual shareholders meeting scheduled for November 16th, 2016. When were those plans delivered? 2 days later, November 18th, 2016. Those plans were not delivered on time for them to be approved by the board. And why? Let's hear from Justin Thoreau. Why did that happen, Justin? And he says, a total fuck up. And I agree with Justin.
Justin said that?
Exactly.
Wow.
We quote it.
Wow, I didn't know Justin said that.
Right from one of his emails. He is enraged. So
wasn't in the script.
His business manager running the project. When you read the email, she's writing to Stephen Shadley Design and to Ernst Architect.
So, counsel, are these not issues that have to be decided by a jury as to whether or not there were damages, what the amount of
Thoreau never disputed them. He did not dispute that Stephen Shadley and the architects, Ernst Architects, failed to deliver those plans timely. And I put it right to Thoreau. Did Norman Resnickow have any influence over the architects? No, I have no reason to believe that. And I asked Pat Dowden at her deposition, did Norman Resnickow prevent Stephen Shadley, did he prevent Ernst Architects from delivering those plans timely? And she said, no, he had nothing to do with that.
Was it his burden to prove all of these things?
Yes, because he is claiming an unbroken...
You moved, but as my colleague stated, it's your motion for summary judgment, right?
Yes, but to show proximate causation, the plaintiff must show that it was the defendant's act or omission that caused an unbroken chain from his conduct to the damage. And we broke that chain irrefutably, not just once, but several times. Thoreau couldn't build a deck until he had approved plans. He's claiming a delay from starting September 1, 2015. He didn't have any architectural drawings until July 2016.
Wasn't there also something in the record that one of the reasons that there was these issues was because your client wanted soundproofing, and there were negotiations and going on back and forth in terms of soundproofing, et cetera?
No, what happened was Norman was sleeping one morning after coming home from heart surgery, and Justin was having his apartment renovated. It was a gut renovation. One of his workers put weight where he should not have, and plaster then was falling down on Norman.
So the answer is yes. Thank you. You have time on rebuttal.
Okay.
Killing me. Absolutely killing me.
Good afternoon. Brian Mueller from Prior Cashman for the respondent, Justin Thoreau. This case is about Mr. Resnickow's 8-year campaign of harassment that he himself meticulously documented against my client, who lived in the apartment above Mr. Resnickow.
So there were negotiations back and forth, right? There were attempts to try to figure out a way in order to soundproof his Thoreau's unit as well.
There were negotiations that were had, and in fact, my client did put some soundproofing down.
Right.
That wasn't good enough for Mr. Resnickow, and it set off, and we have approximately a 10,000-page record on this motion, and now on this appeal. It set off a cascade. And Mr. Resnickow, an experienced...
Allegedly made threats that if he continued in the litigation, that there would be negative press about Mr. Thoreau, about his ex-wife, et cetera. But the gist of this is that, was it your client's burden to show actual damages?
Of course not. We're not at trial. We didn't move for summary judgment. They moved for summary judgment on this claim. It is their burden and their burden alone. And they're not permitted to get summary judgment by just pointing to claimed gaps in the proof. We cite a number of cases, including from this court. The case that I'm thinking of is the Belgium case. It's about the artist Akon with a canceled concert in Brussels, Belgium, where he was, the same went there. They said, you didn't put in medical records showing that he was ill, so we are entitled to summary judgment. And the First Department said no, properly. You don't get to get summary judgment. Your job on summary judgment is to actually prove your entitlement to summary judgment. That switches the burden. They haven't come close to switching the burden here. We lay it out in our papers. In our brief, we lay out all the quote-unquote evidence that they have. And it's chapter and verse of Thoreau didn't present evidence. Thoreau didn't present an affidavit. There's no proof. That's not our job, opposing a motion for summary judgment. Our job is to, if Mr. Resnickow and the appellants are able to shift the burden to us, it's our job to demonstrate genuine issues of material fact. We've done both here, but we didn't even need to get there because all they've done is throw pot shots at our proof, and that's not the way to shift the burden on a motion.
What about your friend? Okay.
Go ahead. I was just saying, it appears that at least a good number of the pot shots are cast by their attorney, not by anybody with personal knowledge.
That's correct as well. Yes, exactly right. It's just argument.
What about your friend's reliance on Mr. Thoreau's email with the salty language about the failure to timely submit the plans?
There is, so we have to look, my friend would like to myopically focus on the delayed completion of the deck. As one of your fellow justices noted, there's evidence from a board member that Mr. Thoreau was responsible for that. But that's just a small piece of what happened here. We're talking about 8 years of uncontested abuse from Mr. Resnikow, for which we've already obtained summary judgment as to liability on our nuisance claim and on our trespass claim. All that the trial is going to be about is damages. And we have shown significant evidence, although we don't believe they've shifted their burden to even require us to show evidence and show that there's a genuine issue of material fact as to our entitlement to damages. We have shown with respect to each category of damages, evidence entitling us to damages. That includes expert testimony, that includes testimony from Mr. Resnikow himself at his deposition, where he gloated. This is 5 years after the fact. In 2021, when he blames Mr. Thoreau himself for his loss of use of his apartment. Loss of use, of course, being the primary deprivation that is sounding a nuisance. He says at his deposition, he said the loss of nuisance was, the loss of use of his apartment that he claimed in this complaint was Justin's fault because what set things off was his total unconcern and unwillingness to deal with the sound issue. So that entitled Mr. Thoreau to do what he did. That's what he says. Okay? We've already been granted summary judgment that that was nuisance. We're going to go to trial, and it's not for us here on summary judgment, for this court to adjudicate the proofs and the evidence at this point in time. There's one, I see my lights on, there's one other thing I'd be remiss not to mention. We, at the last pages of our brief, we note all of the arguments that were abandoned on this appeal. One in particular was addressed in the very last paragraph of the reply brief. And that is our argument that we're entitled to attorney's fees, given the gravity of what occurred in the back and forth with these parties. They didn't raise it in their appeal brief, thus abandoning it, it's deemed abandoned as a matter of law on this appeal. In the last paragraph of Mr. Thoreau, the appellant's reply brief, they say, no, they didn't. We're wrong. Well, that's not correct. The pages they point to in their appeal brief relate to attorney's fees incurred through the work of Ms. Pat Doudna, who's the business manager of Mr. Thoreau. It has nothing to do with our fees. That's what we're talking about. They make no mention. It's dealt with sufficiently and clearly in the order appealed from. They make no mention of it in this record, and there is no basis to reconsider that. It's been abandoned. I see my lights up unless there's any questions.
Thank you.
Mr. Levine, I have a question.
Yes.
We've been talking about burdens of proof, and this was your motion to dismiss plaintiff's damages on the grounds that he hadn't suffered any damages. I don't see where in your motion papers you establish factually that he suffered no damages. Can you explain to me how you proved that?
First,
And was it proved by you, or was it proved by your affirmation or affidavit, or by your clients?
Oh, no. We had both Barbara Resnikow and Norman Resnikow.
Yeah, I know. I've got it. I have it open in front of me.
Put in very detailed affidavits.
I have it open in front of me.
Yes. And I also put in a very detailed affidavit regarding the procedural history.
Right, but that doesn't prove the lack of damages.
No, but I kept showing.
So how did you prove the lack of damages?
Okay, well, let's talk about the zero value theory. That supposedly the value, now keep in mind, Thoreau in response to the May 27th, 2021 order of Justice Lebovitz, when he said, okay, Justin, now it's time to tell everybody your damages, after I had been asking for years for some specific statement, Thoreau serves his expert and damages disclosure. That's the core of his case. That's the target. And Thoreau, in his answering papers and in his brief, gives us a moving target. Instead of 3-year, 8-month delay, it's substantial delay. It's years delay. He's changing his story. He can't do that. He also, I focused on the 3 years, 8 months. I want to focus on the zero value theory. It is negated as a matter of law by the doctrine of caveat emptor. So according to the...
Thank you. Thank you both. EXRP 14 Holdings versus LS 14 Avenue.
Good afternoon, Your Honors. Jennifer McDougall for Defendant Appellate LS 14. The court should reverse the decision below, failing to dismiss plaintiff's claim for tortious interference with contract. Your Honors, the trial court allowed a tortious interference with contract claim to proceed to trial, even though the record is devoid of any evidence of any conduct taken with the purposes of causing a breach of the at-issue contract, which is a lease. In fact, the trial court based its opinion on a theory that the appellant purposely delayed renovations on this retail unit, but plaintiff was unable to point to a single piece of evidence supporting this theory, and actually they didn't even address it in their opposing brief or in the responding brief, which is telling. So then they kind of switched to a different theory, that my client carried out a scheme to keep the retail unit rather than sell it to the plaintiff and take the tenant as its own. But again, tortious interference requires intentional and improper conduct. Again, there's no evidence in the record of any of this type of conduct.
Well, I don't mean to sound like a broken record, but it was your motion, your burden. So again, a little bit procedurally awkward. You're the defendant. Normally you're not, unless you have a counterclaim, you're not trying to prove something. But since you move for summary judgment, you've got to make an affirmative showing undermining one or more elements of tortious interference. So walk me through that.
Absolutely, Your Honor. Well, first of all, I would point you to the JAO Acquisition Corp case, which we cite in our brief. That's at page 7, record 2662, a decision from this court where the court held that a motion for summary judgment could be, was properly granted to the defendant where the plaintiff failed to meet the burden of demonstrating any sort of existence of a factual issue. So I do believe that you can satisfy your burden on a motion for summary judgment pointing to the absence of the evidence, but we did point to the evidence itself, which showed no pattern of this sort of intentional conduct. And actually, Respondent does point to this evidence in their brief, and they point to a letter that was sent in July 2022 that said, hey, this deal has fallen apart, give us your tenant's contact information. And again, that we believe that that was in their economic interest, and as a matter of law, doesn't show any sort of this intent.
Would that be subject to competing inferences, the tenor of that? Or do you view it as it's unambiguous and susceptible to only one meaning?
So, Your Honor, if there was evidence, if my adversary could come up with evidence that that showed a different inference, I would say that there could be an issue of fact there. So say they had a piece of evidence that said, we're sending this letter, but at the same time, we're really going to try to steal this tenant, then you would have an issue of fact that would be subject of credibility. But what we have is this letter, and we have deposition testimony supporting that this letter was sent as sort of, trying to figure out this deal. And there's an absence of the evidence on the other side raising any question as to what the meaning of that letter was. The other pieces of evidence that they have is they point to the fact that in September 2022, our client wouldn't allow their tenant access to the retail unit. I think the timing is really important here. You know, this was in September of 2022. This action was filed in August of 2022. The plaintiff rejected offers to close in July of 2022. They wouldn't sign any amendment to the PSA in June of 2022. And actually their position throughout this litigation is that they had no obligations whatsoever after the time of the Essence deadline had passed in May of 2022. So to say that, you know, we were tortiously interfering with their lease in September when all of these prior actions had happened months and months and months ago, I think really, again, you know, points to the absence of evidence of sort of any intentional misconduct. You know, we have additionally moved on our breach of contract claim. You know, really what our argument is that the order directing my client to return the deposit payment was premature in the absence of a full determination of liability or a review of our affirmative defenses, which the defendant did, or the plaintiff did not move to dismiss. If your honors have any other questions. Thank you.
Thank you.
Good afternoon, Your Honors. Jason Sorolnik on behalf of the respondent. I'm going to start where Justice Higgett left off. It is not only that they have the burdens reversed, but this is one of the more remarkable cases where a party that sought summary judgment to try to dismiss a claim for tortious interference is doing so in the face of an adverse inference order. That is, they decided to not show up for deposition. Their chief operating officer, Mike Forsum, skipped the deposition that the court ordered him to show up for so we could ask him about their very tortious interference to try to steal a blue chip tenant. He didn't show up. They hid documents. They have contemporaneous handwritten notes about this plot that they didn't produce. And we made a motion. We got an adverse inference which directs the fact finder at trial to infer from the failure to show up for deposition and the concealment of these documents that that evidence tends to support our allegations. I've never seen a party subject to an adverse inference walk into court and say, can I get summary judgment in my favor because they don't have any testimony from Mike Forsum saying that he was interfering intentionally. Well, we don't have evidence from Mike Forsum because he skipped deposition, and we have an adverse inference that says that that action directs the fact finder to conclude that if he would have shown up as he was directed to do by the court, he would have testified in a way that would have supported our allegation that they were stealing our client. Same thing about the documents they concealed. So it's not just Justice Higgett's starting point, which is 100% correct, but we are in a unique case here where my friend on the other side is asking this court to shut down a claim as a matter of law based on what she alleges to be a lack of evidence and her failure to show any lack of evidence when she is subject to an adverse inference that says all of the actions that I just described and all the failures to produce will tend to support our allegations. That's the evidence right there, all is said and done. But there is plenty of evidence in the record from which, back to Justice Higgett's point, there are at best competing inferences to be drawn. And on summary judgment, every one of those inferences needs to be drawn in favor of my client, the plaintiff. We're not moving. We're going to present this evidence at trial. What's that evidence? We have an actor, the seller of this of this unit, that scheduled a fake closing after blowing the time of the essence deadline, precluded my client from showing the blue chip tenant the property as the blue chip tenant wanted to get it ready so it could enter at the time that it was going to take over. And then it asks our client, hey, can you give us that blue chip tenant's contact info? We'd like to reach out to them. Now, I think the compelling inference from that, and perhaps the only inference from the body of evidence, is we know exactly what they were trying to do. They wanted to steal that $20+ million lease for themselves. But I don't need to prove that because I didn't ask this court or the court below for summary judgment. That is, at a minimum, a reasonable inference to be drawn from each of those pieces of evidence, let alone the body of evidence taken together, setting aside the adverse inferences that we started with. The idea that a fact finder cannot draw an inference from any of those pieces of evidence, let alone all of them, that the scheme here was to blow my client's ability to take possession of this unit after my client found and negotiated a very lucrative lease so that they can go ahead and contact that same tenant and say, hey, we already built this for you. Instead of giving the lease payments to the person, the entity that you negotiated with, maybe you should just lease it from us. if that's not a reasonable inference to be drawn, then I don't know what is. And so, to Your Honor's points, the burdens here are totally reversed in the appellant's mind, and the burdens here couldn't possibly be sustained even if we didn't have the adverse inference. With the adverse inference and the evidence that we've cited in our papers, there is more than a reasonable inference. There is a compelling inference that that was exactly the plan, and that's what we intend to prove at trial to the fact finder. So unless the court has any other questions, I appreciate your time, and I'll rest on my papers and my argument.
Thank you.
Thank you, Your Honors. With respect to the adverse inference, they do obviously point to a discovery order issued by this court. If you look at Record 16, what the court below says is that there was a failure to produce certain garden variety construction documents that were produced by other parties in the action, but our client didn't produce them. And I think what the point of that is that it is a thumb on the scale. It's not the entire weight. And so,
Isn't that the basis for the construction delays? Isn't that part of the theory that the construction delays were intentional, and those documents and the deposition would shed light on that?
So I don't believe so, Your Honor. I think the issue is that there's no evidence of any of sort of this intent. We'll say my client, delayed in, negligently delayed in getting this unit done in time. There's 2,000 pages in this record. There's not a single shred of evidence that shows there was any intent or improper conduct underlying that in order to sort of steal the lease. They do have the construction documents. They took 5 depositions. They were non-party depositions. We took depositions. But there's not a single piece of evidence in the record showing any sort of intent to steal this lease from the plaintiff. What you're seeing is my client is trying to close, offering them multiple opportunities to close, showing up at their offices and saying, hey, please close. They refuse to close and then blame us for their tenant ultimately, not going forward with the lease. We offered them possession multiple times, which would have allowed them to comply with the lease and ultimately still reserve their rights to sue us if they felt the condition of the unit was improper. Instead, what they're saying without evidence in the record is that we had this sort of improper scheme to steal the tenant, but there's nothing on the record to support that.
Thank you. Thank you both. People v. David Martin.
Good afternoon, Your Honor. Stephen Strather from the Office of the Appellate Defender on behalf of David Martin. I'd like to focus my argument today on our claim that New York's permissive presumption in Penal Law 265-14 was unconstitutionally applied to Mr. Martin under Bruin. So the presumption says that possession of a gun gives rise to a presumption that you intended to use it unlawfully. The problem is that Bruin defines the scope of the Second Amendment right such that possession of a weapon loaded in public with or without a license is protected by the Constitution. The presumption says that conduct, that precise conduct that Bruin says is protected under the Constitution, gives rise to criminal liability.
Does Bruin say that you don't have to get a permit in New York?
Bruin doesn't speak to whether or not you have to get a permit in New York. Bruin says that...
Bruin didn't invalidate all of New York's permitting statutes, did it?
No. But that also...
Bruin didn't say that the right was absolute. It did not state that New York could not impose certain restrictions.
Yes, but that's a red herring, Your Honor, because Bruin does say that the right is the right to possess a gun with or without a license in public. If a state wants to regulate it, those regulations have to comport with history and tradition. Here, though, our argument is that a presumption that possessing a gun gives rise to criminal mens rea can't stand after that, because the act of possessing the gun with or without a license, Bruin says, is protected by the Constitution.
So we have stated repeatedly that under Bruin, in order to have standing, you must have applied for a license.
So this claim really doesn't involve standing in that way, because we are challenging the use of a statutory presumption against Mr. Martin at his criminal trial. His standing there is that he's being prosecuted, that the presumption was given to the jury. The judge gave that instruction to the jury. So we're arguing that was unconstitutional under the Second Amendment. We don't have to show standing in that
So
way to make
I'm
that claim.
sorry, again, so you're stating that under Bruin, you can use a weapon unlawfully, intentionally use a weapon unlawfully against another.
No, I am arguing that under Bruin, you can possess a gun in public with or without a license under the Second Amendment. And this state said, this permissive presumption says,
You're saying that you could possess a gun with or without a license lawfully in New York State?
I'm saying Bruin says that you can do that, that when you possess a gun in public, if you...
You're forgetting one important aspect, that Bruin doesn't say that New York cannot regulate that.
Again, Your Honor, that is a red herring. That is not relevant
It's
to
not
our
a red
claim.
herring, because the presumption here is that if you unlawfully possess a gun, that then that's a presumption.
Again, Bruin says that
You
possessing
want
a
to take
gun...
the unlawfully part out. You want to take, if you possess a gun, Bruin protects that, so you can't have the presumption. But the presumption only applies if you unlawfully possess the gun, meaning you don't have a permit for it in New York.
Again, Bruin defines the scope of the Second Amendment right as the right to possess a gun in public, as that right existed in the 18th century.
It's not absolute, because they didn't say that we don't have the right to regulate it.
That's correct. New York has the right to regulate it. New York does not have the right to say that presumptively constitutional conduct. Again,
So what would it mean to regulate it if the violation of the regulations resulted in no criminal penalty?
I think that the answer here is more that New York, when you're walking around possessing a gun without a license, Bruin says that the Constitution protects that. Now, a state can regulate it if those regulations are lawful, but what the state can't do is say the mere act, the act of possessing the gun, which again, Bruin defines as what was the right in the 18th century. There were no gun licenses
But it's
in the 18th
not the mere
century.
act of possessing the gun. You're forgetting the permit part.
I'm sorry, Your Honor, I feel like we're getting across.
Yeah, we are. So you're arguing that the presumption of possession, that the presumption stating that if you possess it, you're doing so with the intent to use unlawfully. You're stating that that is unconstitutional under Bruin.
I'm saying that because Bruin says that that the right to possess a gun in public is protected under the Constitution, you cannot presume an
So
intent to
that's
use
what I
it
just said.
unlawfully.
So you're saying that the presumption is unconstitutional.
That's correct. That is what I'm
Okay.
arguing.
So now, under these circumstances, however, given the facts of the case, my question is, did the defendant attempt to use the gun, or did the defendant use the gun unlawfully against another?
No, he came into a building. He was there to perform work. He punched someone. There's no doubt about that. But of course, punching someone is almost like proof that you didn't intend to use the gun, because if you wanted to use the gun, you would have. So you used your fist
What happens
instead.
after the gun fell out? He reached for the gun, then there's a struggle for the gun's taken away from him. What happened with all that?
Yes.
He reached for the gun. I think one could
He reached for the gun, and the testimony in the record is that he had the gun in his hand.
That is actually not the testimony in the
So what was the testimony? Because I went through the record, so I thought that that was the testimony. I thought the testimony was that he did, in fact, reach for the gun after the gun had fallen out, and he was and he was holding the gun.
So there's actually contradictory testimony. At one point, Mr. Vargas
now
says...
you've changed, so there's no evidence, and now there's contradictory evidence.
The first, Mr. Vargas' first test, he
Be clear.
testifies that he reaches for the gun. Then he testifies on cross-examination.
Well, excuse me, when you say he, you mean the defendant.
Martin, yes.
Right, your client reached for the gun.
And then he testifies on cross-examination that actually Mr. Martin and Mr. Silviera reach at the same time, their hands are on top of each other, and then they wrench the gun out from underneath both of them. So it's not actually clear if he ever got his hand on the gun or not. But I don't disagree that he reached for it. I'm not disputing that.
So would that not be sufficient for intent to use unlawfully? If you're reaching for the gun, why is he reaching for the gun?
It wouldn't in this case, because this is a constitutional claim, and the use of the presumption has to be...
Well, that's a red herring, okay? That's a red herring. The constitutional issues are red herring, so we're going to put that aside. If, in fact, he reached for the gun, would that not constitute intent to use unlawfully against another?
Not in this case, because the use of the presumption has to be harmless beyond a reasonable doubt. If that's the only
This is not a
fact-
presumption. This is evidence now. We're not talking about presumption. We're talking about the fact that he reached for the gun. He had it in his hand. That's not evidence of intent to use unlawfully?
I am saying that if that's the only fact that can be pointed to in this entire record, then the use of the presumption, which we're
Again, we put aside the presumption, we put aside the constitutionality of the presumption. We're only dealing with the facts. The facts of the case, if he reached for the gun, as was testified to by one of the witnesses, and perhaps that's to testified to as another witness, but you're saying there's a contradiction between their testimony. If in fact he reached for the gun, is that sufficient under the law to show use with the intent to use unlawfully against another?
I don't believe so. No.
Why
I don't-
not?
Why? Because he could just as easily have been trying to grab it so no one used it against him.
Oh,
Put
yes.
it back in his pocket. Those are just as reasonable and
Even if that's the case, then the jury made a determination here,
Exactly.
right? So why should we disturb their determination?
Because again, this is a constitutional claim.
Again, counsel, I said we're ignoring that. We're putting that aside. We're only looking at the facts of the case. We'll deal with it further on rebuttal.
Excuse me. Good afternoon, Your Honors. Samuel Goldfein for the people. I think the piece of Bruin that's been missing from the discussion is it's in the second sentence of the case. Bruin didn't confer an unfettered right to possess a gun in public for self-defense. It conferred a right for law-abiding citizens to have and carry a gun publicly for self-defense. And in footnote 9 of the majority opinion, they explain that one of the ways that states can ensure that weapon possessors
Yes,
are in
we
fact
know the
law-abiding.
footnote. We're fully familiar with the footnote. We're fully familiar with the decision. So my reading of the transcript, it's unclear, or is it unclear, as to whether the defendant actually reached for the gun or did not reach for the gun, or that the gun fell out and he reached for it? What exactly was the testimony?
Absolutely, Your Honor. So how the gun got off defendant's person is unclear on the record. You can't make it out in the video. There's no testimony about how it was there. There is testimony that they cleaned the lobby earlier and there was no gun there. And then with the magazine in his pocket, it's very clear that it came from him. Once the gun is out, so
Well, the magazine, only because the magazine was the same as the
magazine
as
in
the
the gun, Your
magazine
Honor,
in the gun.
and loaded with the same type of ammunition as well.
exactly.
So once the gun is out, Mr. Vargas sees it while it's still underneath the bench. He shouts he has a gun. Mr. Silverio turns around. He sees the gun. He sees defendant reaching for it. And while they're restraining him, defendant is struggling. He's kicking his arms and moving his legs, backwards. So it's clear that he's trying, maybe not trying to get it, but once the gun is out, he grabs it. The testimony is unequivocal that defendant reached out and, quote, grabbed the gun with his hand. This is Mr. Vargas at 325 to 26, and then again at 331 to 332 of the record. And that Vargas grabbed defendant's hand to stop him from doing anything with the gun. Mr. Silverio, who had stepped a couple of feet away to start calling the police, he hears the cry of the gun, he turns around, and he sees that the gun is in defendant's right hand and that Vargas is holding defendant's hand. That's Silverio at 205 and 218 to 219 of the record.
So would there be a reasonable view of the evidence that the defendant reached for the gun in order to prevent its use by the two other individuals against him?
I don't think that view of the evidence would be reasonable, particularly in light of the circumstances of this case. Defendant, rather than answer a very simple question, responded by punching Mr. Silverio repeatedly in the face, and then when the fight that defendant initiated turned against him, he reached for and grabbed hold of his loaded gun. Under those circumstances, the jury was surely able to infer that given defendant's resort to violence over absolutely nothing, he was willing to resort to at least the threat, if not the actual use of
But
deadly
what about the argument that when Silverio, I think he tried to stop him as he's going onto the elevator, right? And the defendant then punches him.
Correct. Mr. Silverio put his arm in front of the doorway of the
Right.
elevator. He did not touch the defendant.
So what about the theory that at that point in time, since the defendant had a gun, he could have used the gun as opposed to punching him?
That's plausible. I don't think there's no theory of burglary, Your Honor. It's not that defendant came in here to commit some sort of crime. It's clearly an escalating scenario. I will say that it takes a certain amount of hubris to pick a fight with a New York City doorman whose job it is to keep unwelcome visitors out of the apartment, and perhaps he was willing to do that because he knows that in the event that the fight turns against him, he has deadly violence in his pocket. Certainly under the circumstances, I don't think he came into the building to attack Mr. Silverio. He came into the building for whatever reasons. The notion that he's working is certainly not borne out by the record. There's no
How
evidence.
important was the statutory presumption to your case?
It was an afterthought, Your Honor. Certainly the intent, I think, is fully borne out on the record. One brief point on the statute, I know on the presumption, I know Your Honors are familiar with the footnote, but the presumption only applies in the instance of unlicensed possession, and that is why it applies here. It stands to reason that someone who was intending to be law-abiding, who wanted to possess a gun only for self-defense, would go through appropriate channels, would have it properly licensed. And the failure to do so in a vacuum is evidence of some unlawful intent. Certainly, in light of the actual intent that's displayed by his actions in this case, the presumption is an afterthought.
The presumption was, however, told to the jury, right?
Yes, Your Honor. The
jury
was
was aware of the presumption.
They were made aware of the
But
presumption.
they,
yes, Your
but the charge also states that they could reject the presumption if they wish to do so.
Yes, the judge's charge was appropriate. I don't think there's any challenge in that regard. The people pointed out the jury could take or leave the presumption. They pointed out all the evidence of intent that I've just recounted for this court.
Well, so let's assume for a moment that the charge, that presumption is now unconstitutional under Bruin. Was that error of such a dimension that it would warrant a new trial?
I don't believe so in this case. I believe the jury was readily able to infer intent from the evidence in this case, from defendant's unprovoked violence, his escalation in response to a mere question, to a physical assault.
Thank you.
Thank you, Your Honors.
Could you walk me through your standing argument one more time?
Sure. So there's sort of 2 points about standing here. First, on the permissive presumption, we are arguing that the use of this instruction to the jury using this presumption was violated the Second Amendment. Under those, the standing at that point is conferred by the fact that the instruction was given. It's his prosecution, the instruction was used. That's no different than a constitutional challenge to any other jury instruction. So we don't have to show standing in the way that you would normally show it when it's a regular, like a challenge to 265-0303 under Bruin. We have standing arguments on that too, but on the permissive presumption, it's a different argument because we're just challenging the use of that presumption at the trial. And so I believe their standing is confirmed by the fact that Mr. Martin that instruction was given to the jury at his trial, and that gives him standing to raise
But
the
you
claim.
also are challenging, because he was convicted under 2 counts.
That's correct.
So you're challenging both counts.
That's correct. We're challenging 265-0303 under Bruin in a larger
Straight Bruin,
sense.
and then you're challenging this under the presumption.
That's right. And so now a couple of things that the respondent said that I want to respond to. The first is that there actually is testimony about how the gun got out of his pocket. Mr. Vargas testifies clearly that the gun fell off from Mr. Martin during the scuffle. Like, he didn't take it out of his pocket. It fell out of his pocket. And I also want to say that on pages 323, 32, and 33, and 328, the testimony is that Mr. Silviero took the gun from both of our hands while we were struggling. That's Mr. Vargas. So I think the idea is that there is like a scuffle, their hands end up on the gun. Again, I'm not disputing that Mr. Martin reached for the gun. I think if that's the only fact from which intent can be inferred, then it is not harmless beyond a reasonable doubt that this instruction was given to the jury, and it was not of no moment. The prosecutor referenced it in their summation.
But
He
the
talked
charge
about it.
specifically states that you can reject it or you can accept it. It's up to you. If you find that the evidence does not support the presumption, you can reject it.
Sure, they can reject it. My point is that Bruin doesn't allow the instruction to be given because...
Did the defendant object to that instruction?
Yes, well, the instruction was objected to in the 330-30 motion, and the respondent concedes that it's preserved because the judge explicitly ruled on the question.
Thank you both.